Because what I want to do is, I want to start.
Oh my God.
Which one was he trying to connect to? All the devices from iPhone to a lower version. I said, I didn't know that. Anyone, if it's 5.5, potentially it will prevent the virtual control from working. Now, starting yesterday, they started having more problems. And eventually it seems like it pops up. I don't know why, but it does.
All right, we're gonna bring Mr. Tolbert out when you guys are ready, please.
How many inmates you have, Judge, on this one?
Yeah, we have 6.
6, okay.
Yep. 3 bond hearings and 3 pleas. We're gonna take care of one carryover from this morning. We had a transport issue. You ready, Mr. Forte?
Yes, Judge.
Great. All right. This is position 2 from this morning's calendar, State versus DeAnthony Tolbert, 19 SC 167684. Good afternoon, Mr. Tolbert.
Good afternoon, Mr. McBurney.
How you doing?
I'm doing
Good. Apologize for the setup. I know you're looking in a strange direction, but we're getting this courtroom ready for trials. We're hoping in a few weeks to start jury trials. They will happen in this courtroom. But in the meantime, Ms. Snyder has filed a bond petition on your behalf. So we're going to talk about bond in your case. Ms. Snyder is going to tell me why you ought to get a bond or a lower bond if you already have one. Ms. Ocom, the prosecutor on your case, is on one of these 9 million screens. And she is going to share with me the state's view as to whether you should get a bond. And I'll let you know what's going to happen. Okay?
all right.
All right. Ms. Snyder, when you're ready.
Mr. Tolbert is 23 years old. He's an Atlanta native. His mother recently moved to Macon, and if he were to be released, he would be able to reside with her. He would also be living with his older sister, his niece, and his little brother. So between the 3 adults in the house, they would absolutely make sure that he came back to court when called, even though it's a little bit farther outside of our typical Metro Atlanta radius. He also is supported by his child's mother in the community, so he does have significant community support. Prior to being incarcerated, he has been in since the day he was arrested, so a little under 2 years, a little over 2 years. We've never argued for a bond. So we are here to ask for that today, given that there might be some delays getting to trial and some of the things that Mr. Tolbert has experienced in the last 2 years at the Fulton County Jail. He doesn't have any felony criminal history, so I don't believe he would be a risk to reoffend while he is out. And we would be absolutely okay with a 24-hour curfew with the standard exceptions, church, court, meetings with me, medical appointments. One of the reasons we want him to go back to the streets, not to the streets, but home, is he is dealing with some mental health issues that are not being properly treated at Rice Street. There is a plan for him to go back into counseling services with Families First. to restart his mental health treatment. And he recently contracted COVID while in the jail. Thankfully, he has recovered. But so he's had a difficult time in there, and he was also assaulted at one point. Prior to being incarcerated, Mr. Tolbert was working with Signature Staffing at 2 different places through Signature Staffing. One was called
Club
Club
Chef
Chef.
and Fresh Express. I was going to start working at the chicken plant, and I think it's at Worth.
Hopefully not the one up in Rome,
Yeah.
wherever.
Well, that one's a little far.
Hey man, wherever the money's good. Yeah.
Yeah.
So there is a possibility that he could go back to Signature Staffing if he's released, but we do understand if Your Honor would require a 24-hour curfew. Given that he is a public defender client indigent, he would not be able to post any bond of great significance as well as paying for an ankle monitor. We understand if Your Honor wanted to put an ankle monitor on him. He said that they would work it out to pay for it if that is required, but I would suggest in the alternative, pretrial level 3, and where that way he's not paying for the ankle monitor, but he is getting some regular supervision if he is to be released. Part of when he was assaulted, he sustained an injury to his jaw. His jaw was broken or cracked or fractured, that he's also not receiving significant medical treatment for.
Excuse me, Mr. McBurney. I had got assaulted by an officer and he cracked my jaw. And what happened was that they put me in the hole and refused me medical treatment. So my jaw is now sitting like this. So they told, okay.
Okay, but I'm hearing you that time at Rice Street hasn't been a great time for you, and I'm sorry about what happened to your jaw.
And I have provided him with some civil information for him to pursue that he understands that I can't assist him with that. And then I know this isn't really the time for facts, but just a little bit. He is not alleged to be the shooter in this case. He was just in the vehicle. And then I believe Mr. Pinion said at one point that they don't really have a case on the co-defendant without his testimony. So we believe that this is probably not going to go through with him being charged with murder. But we would respectfully request that you grant Mr. Tolbert a bond so that he can assist me in preparing his defense and so he can adequately take care of his mental health issues and his medical issues.
Okay. Ms. O'Connor?
Yes, Your Honor. The state is objecting to bond, Your Honor. I understand the defendant doesn't have a prior felony, but I would know for the record that he was picked up in Chicago. This occurred, I believe the incident happened January 14, 2019. While he was in Chicago, he picked up an offense. He's being charged in Chicago for the charges manufacturing, delivering a controlled substance, which is a felony. He picked that up on January 21st, 2019. So it happened here. And then he went to Chicago. While he was in Chicago, he picked up a felony. Obviously, the Chicago case is on hold because he was extradited back to Atlanta to sort of handle this case first. So I don't know what Chicago is doing with it, but I'm sure that they're just waiting to see what Atlanta will do, which makes it the defendant likely to reoffend because this crime happened and he went to Chicago. And while he was in Chicago, he picked up a new case. He has failed to appear before prior. In 2018, he failed to appear in a case. The state believes that he's a danger to the community. Obviously, I don't want to go through the facts of the case, but basically the victim was just an innocent bystander just walking on the street, and the defendant and his co-defendant accosted him. And there was a scuffle and the victim ended up dead because he was shot. I think the circumstances of that case also, of this case, proves the seriousness of the fact that they didn't even know him. They didn't know who he was. He was just an individual walking on the street and they stopped him. I understand as of now that Mr. Tolbert says he's not the shooter, that it was the other individual that shot. I think, as the law says, it doesn't matter if you're the shooter or not, if you're involved or you helped, which he did, because then another bystander tried to stop and intervene and Mr. Tolbert told him to keep going. So based on all of that, Your Honor, I don't believe anything that the defense has brought forth as based on the AL factors, would give the defendant rise to a bond in this case. Again, he has been arrested before. He has failed to appear. He picked up a case while out on this case. And at the time while he was in Chicago, he knew that the officers were looking for him and wanted to talk to him. He was aware of that, but he stayed in Chicago. For all of these reasons, Your Honor, the state objects to bond. I believe Ms. Rawlak has a written statement from the deceased father. She would like
So I have a couple questions for you, and then I'll hear from Ms. Rolak. How is it, Ms. Okam, you believe that, or why is it that you believe Mr. Tolbert knew that he was a person of interest in the shooting when he went to Illinois?
Because he told the officers that he heard that the officers were looking for him, that he spoke to his mom, and they spoke to some of the family member that he was aware of, and he told, because he had a custodial interview, and he
Okay,
told
so when what you're saying is your review of Mr. Tolbert's interview with Atlanta police after he came back was he said, yeah, I knew you guys wanted to talk to me, but I went to Chicago. No,
I'm not saying that he knew that he wanted to talk to him and he went to Chicago. He was already in Chicago and he knew that the officers were looking for him, but he never actually came back or responded or talked to the officers while the officers were looking for him.
Okay, all right, it's a little different, but I get it. Okay,
Yeah.
Thank you. Ms. Rolak.
Good afternoon, Judge. Can you guys hear me?
Yes, ma'am.
Okay. I have a statement from the father of the victim. His name is Frank Fluitt. He
Can you
says,
spell the last name, please?
sorry, Fluitt. Judge McBurney, thank you for allowing me to address the court today via letter. My son, Frank, was my firstborn child and my firstborn son. Me and my wife love him dearly. I cannot put into words how much the loss of him has hurt me and my entire family. We have lost a brother, an uncle, a nephew, a father, and a son. My son's murderous death ruptured the heart of my family, and it will never be the same. Mr. Tolbert seeks a bond so that he can be free to be with his family, see his daughter, and be amongst the people that love and care for him. Mr. Tolbert took that away from me and my family and the ability for my son to be with his 7-year-old daughter. Nelson Mandela said, "For to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others." Mr. Tolbert is light years away from beginning to understand the meaning of freedom. Thank you, sir, for listening to me today, and I hope the very best for all of you.
Thank you, Ms. Rolak, and please let Mr. Fluitt know that I appreciate him sharing that, and I'm very sorry for his loss.
Yes, Judge.
Ms. Snyder, anything you want to add in response to what you heard from Ms. Okam?
Just very briefly. Mr. Tolbert was a cooperating witness in a burglary investigation, and when he was in Chicago, that was his understanding, was that they wanted to speak to him about that case. He had no idea that he had any other involvement in any other case.
What was the time frame, as best you know? Mr. Tolbert is supposedly in Atlanta. This situation happens, then he's in Chicago.
I don't have those dates off the top of my head because his file is one of the ones that's in a box somewhere. So I just have my notes.
Okay, but is it months apart or days apart?
I would say a few weeks. A few weeks.
Like a month, like 4 or 5 months. No, like a month or so. But I didn't honestly.
You don't. I'm not asking you to share anything. I was just curious if Ms. Snyder was in a position to put together a chronology. Mr. Fluitt's son is killed, and then at some point, Mr. Tolbert is in Illinois. I was wondering.
I believe it's that he's cooperating with the burglary investigation. Mr. Fluitt is killed, and then he is picked up in Chicago and brought back to Atlanta.
Okay. So Mr. Tolbert wasn't arrested at the scene or immediately afterwards because there was this intervening time during which he went to Chicago.
Right, and he, right,
What are Mr. Tolbert's connections to Chicago?
just to visit, never been.
But it was a family there, or it was, I'm gonna go watch a Cubs game?
Honestly, I had never left Atlanta before.
Okay.
And being here 20, 21 years of your life, and you always want to go somewhere else. You always want to see something new.
But you don't have family in Chicago?
No, I don't have family.
Okay. All right. And if you did make your bond, you would live with your mother in somewhere near Macon?
Yes, sir.
And I do have an address to provide the court.
Okay. Are there things that you or I should share with the medical staff at the jail in connection with getting Mr. Tolbert whatever assistance he should be getting in terms of counseling or medication on that side? So not the jaw situation, which is also a problem, but.
I know that they had records when he went into Rice Street. I'm sorry if I'm off one. And then he also provided a self-history and the medications that he was on. And I believe that, if I remember correctly, from 2 years ago, there was something like some of the meds that he was on, they couldn't give him. I
Okay.
don't remember what it was, but
Okay.
Excuse me, Judge McBurney, the medicine, they had my file on their desk for 6 months before they even came and see me. And what happened was they told me that my medicine was a narcotic. So I asked them to give
Your
me
medicine was what?
They told me that they couldn't give me my medicine because the medicine that I take, that people may sell it in the jail, and they didn't want that. So I asked them, can they give me something lesser?
Mhm.
And they told me, no, they can't. But when I end up talking to mental health supervisor, she told me she was going to write me a letter of recommendation to give to the judge. And so that I may be released to get my medicine. You know what I mean? And what happened was they stopped coming to see me and everything.
Okay. Well, that we can look into, because that's certainly something that needs to be addressed. All right. Well, Mr. Tolbert, at this time, I'm not going to set a bond. I'll tell you why. One, obviously, these are serious charges. But two, I am concerned about your ability is not the right word, but your willingness to appear for court when we would next have court. Because the next thing on the docket for you is going to be trial of this case. These are as serious as charges get. And the fact that sort of out of the blue, you decided to go far from Atlanta soon after this incident makes me concerned that we would not be able to ensure that you came to court when we needed you to come to court. Now, having said that, there are two important caveats. One, I'm going to ask Ms. Snyder to talk with the folks at the jail about making sure you get the medication you need. And if the answer is there's some hiccup with that, I'll get involved if I need to. And the second thing is, if we are not able to get this case to trial in the next few months, then I'd ask Ms. Snyder to renew this conversation, and we can think about other options. But the amount of bond you'd be able to make, and the fact that I have had too many ankle monitors removed, and then we lose track of the folks we're trying to keep track of, makes me not comfortable that I could set a bond that would ensure that you came to court rather than went to Chicago when we needed you to come to court. Ms. Ocom, anything else in this matter?
Yes, Your Honor. I believe this morning we talked about a firearms examination again. I have talked to Mr. Pinion, and that's not what it is. It's the DNA, which I talked about this morning. I will be filing a motion through my investigator for a buccal swab for the defendant tomorrow. And then as soon as I get that, I will turn it over to GBI, and I will have them expedited so I can turn it over to Ms. Snyder and Mr. Devin.
And the DNA connection to all this is that there may be DNA from the gun, or what is it that you're
There was a
trying to match?
DNA on one of the cases left on the scene. GBI got a DNA profile, but we haven't compared it to the defendant's profile.
Okay. All right. And you already have DNA from the co-defendant. You're trying to get it from Mr. Tolbert.
Yes, Your Honor.
Okay. All right. So that's where we are, Ms. Snyder. Let me know, please, if you run into any friction over at the jail. Okay. Thank you.
Your Honor, this is all I have. May I be excused?
Yes, ma'am.
Thank you.
Ms. Nelson, I have a question for you. I was not expecting you to serve as a litigation manager for the Judge LaGrua cases. Did you agree to do that, or should I be looking for someone else on this call? Because I don't see any other names.
I think that probably Larry Smith, he just sent me an email. He wanted to double check on the Zoom log for today. So maybe he is going to handle that. I'm going to see if I can send him that link. And
Great.
he should be on shortly, but I'll confirm before I sign off.
Fantastic. Thank you.
Mm-hmm.
So while you're doing that, I'm going to turn to the calendar that we've got. Is there a particular order in which folks at the jail want to go? Hello, Ms. Alexander.
Judge, how are you?
We're trying to make this work. In fact, I can take this off now that we're going virtual.
I was confused about the courtroom activity, but.
Well, we had a transportation issue, and the gentleman whose bond hearing we just had was supposed to be here this morning. He was not brought over. So that threw a little wrench into things, but we dealt with him as soon as he was brought over.
So Judge, I think the jail is prepared to go in the order of the calendar.
Okay.
There's some defendants on the same floor. I can actually see them, but.
You know, I see several folks. We've had a gentleman in 2 South Booth 1 for a long time now, but so you're saying we'll start with Sanchez Hartnett?
Captain
That's the
Beck,
first position on the calendar.
first position on the calendar. That's what they were prepared to do.
Okay.
I'm sorry to interrupt, but can someone email me the link? It's not showing up on your Outlook. So.
Sure, I'm using the link from this morning.
Oh, we're using the same link? Okay.
No one ever gave me a link for Judge LaGrua's situation.
Okay, well, then I'll send that to Mr. Smith. Okay,
Oh, hold
thanks.
on 1 second. You have a link?
It's the same link, Judge. That's how I got in, the one you sent me.
They piggybacked on that. No problem. Okay.
Well, but then there's going to be an issue because it sounds like I can't figure out why there are no attorneys. They are all on another.
Oh, you didn't sign in. We should sign in on the one that you attached to the hearing, Judge.
So just before anyone does anything, I never got anything from what I'm going to call LaGrua's team as to what the Zoom would be. And Ms. Alexander and I were working yesterday to set up this booth situation. And the only link I had was our link from this morning's calendar. And that's what I shared with Ms. Alexander. So that's what we need to use. We don't want to lose these booths. So Mr. Smith needs to get his act together, get on this call, and he's going to need to let all the lawyers who are sitting on another Zoom call know that they need to get into this Zoom.
Okay, well, it looks like Lee set this up. So I went on and I just sent you the link and I sent it to Larry Smith. So I need to, I think if you.
We probably need to send the link that he's on is where the computers are, because that's the link that I attached to the.
Yeah, we can't move the jail. The jail needs to stay where it is. That was an effort to get them connected to this call. So whatever one Lee or Larry or whomever set up, someone needs to go on there to say, here's your new Zoom link. And it's the Zoom link that is live now, which is the one, Ms. Nelson, you did for this morning's hearing. That's where everyone needs to end up, is this morning's link.
Oh, okay, the only thing about that, Judge, is that this morning's link is only going to go till 2:00. So I think.
Well, how do we extend that?
Yeah, just go into the Zoom link. Ms. Nelson.
Okay.
Recorded minutes.
Okay, the only thing about that is what I was told, and I don't know if this is true, that I can't do that when the cameras in the courtroom won't sign up because that wasn't the initial setting up. So I'm not sure. I'm just saying what I was told before I just.
Okay, well, we've got a Zoom guru here. Ms. Nelson set up the Zoom session that all these booths are plugged into. She programmed to end at 2 because she didn't know that we were going to piggyback with all these LaGrua cases. And so the concern is if she goes in and says, I didn't mean 2, I meant 4. Will we lose all of the Zoom room stuff, or will that automatically expand out?
I think the only detrimental thing you could do would be to shorten the meeting, because there's a chance they might leave at the end of the calendar.
Yeah.
It's the outlook.
Yeah, let's try it, Ms. Nelson. Let's try stretching it to 4, and we'll see what happens. Yeah.
Okay, all right, let me see what I can do on mine.
Okay. Apparently there was a.
Well, no. I'm gonna have to do that because I'm the one that actually invited these devices. And I can do that. I'll run back to my office.
Okay, so you'll extend this link to 4 o'clock?
So there was one calendar invite that I went to the people, and then there was one that just went to the machines. And I
Okay.
said that one. It was something I was working with Shay on, but it was just easier.
Good.
We were talking.
Okay.
I'll go do it. So
Okay.
extend it
To
to 4.
4, yeah. But Ms. Nelson should do the same, because won't it shut down the hearing for all of us if she doesn't stretch hers?
No, I mean, her Zoom meeting should only end when she ends it,
Okay.
whether it goes past the time she's scheduled or not.
Okay, so she sent it out as a marker telling the world it's 9 to 2,
Yeah, so-
but if the host doesn't end it, you just blow past it. Okay.
They should just keep on going.
Okay.
The host doesn't end the meeting.
I will not end it.
The devices listen to a separate invitation.
Okay, so
I'll
you,
come in and explain this a little bit.
okay, great, thank you.
Yes.
Okay, so I went on and extended mine, so we'll see how that happens.
Okay, thank you for everyone's patience. Yes, sir.
We have someone here for Hartnett.
Okay, Hartnett's first up, once we can get Hartnett and Hartnett's lawyer on the screen.
Okay. All right, man.
Sure, thank you.
You're doing all the defendants in custody.
Correct, everyone else is going to be in one of those booths out at the jail.
Okay.
And again, I apologize to all the deputies and detention officers. I know we were trying to start at 1 and we're not, but we're working through things as quickly as we can. This is our first test of this process. I think it is a great process that once we get a good rhythm is going to make life a lot easier for all of you out at Rice Street, because you don't have to move people around as much. But today, a little bumpy. Appreciate your patience. That's something that would be great to have on the calendar. I've heard that he's on the 7th floor. So do we know which booth Mr. Hartnett is in? He's right there. Thank you. It's 7S booth 1.
7 South. Mr. Standard, is Mr. Standard still with you, Judge?
I'm in my office now, so the invitation that is controlling the devices goes until 4:30, so we should be good.
Great. Thank you.
Set up that time, but the question is for the camera, like the defendant that's in 7 South, I just see the top of his head. Is it the way that the computer is? Does he need to sit back, or how does that?
So it's that we've never had anybody actually sitting on the other side when we've looked before. So usually it's a mop pail or some mattresses. So now that I see that they're kind of down, we just need to go and adjust the computers to kind of angle down a little bit more.
Yeah.
Yeah.
So Judge, did you make the announcement that I want to thank you for doing this pilot with me so we can work out these kinks?
You're welcome. No, I did say that I'm appreciative of everyone's patience here as we get this up and running. These are the growing pains, but this will work real well once we get all this stuff sorted out.
Absolutely.
Yeah.
So Isaac, look at 1 North. We can see him really well. So I don't know if that position of that camera is different from.
Well, we'll also need to see how well we can hear them when they're far enough back that we can see them. There may be, it may be when we're not actually in court, we test it out by having a detention officer pop into each booth, sit down, and then we adjust camera and whatnot so that they're not 15 feet away so we can see them, but then we can't hear them.
Yeah, I would be willing to, to assist with that. We would need, somebody on the inmate side, and then somebody, on the public side, maybe me, and then some people on Zoom to kind of give a thumbs up, thumbs down on the volume.
Who said 30 seconds? Oh, go for it. I didn't hear 30 seconds.
Sorry.
Is this something new they're trying with the turnbooks now?
It is. It is. It's a way to streamline things both for the courts and out at the jail. We would assign, the plan is to give a judge, two judges a day. You get all of booth ones. So that would mean that on my day, booth one, and there's one booth, as you know, on each side. So one north, one south, two north, two south, all the way up. So that means the folks there, when they get the calendar for McBurney, they'd say, all right, that guy's on 3 South, just send him to the booth. You don't have to worry about rolling a cart or saying you got to go down to that courtroom 2 or anything like that. Inmates can stay on their floor. They just come to the visitate. You close the door, it's private. And we should be able to see more inmates in a particular day, which is going to be helpful because in a week, we're going to have 2 grand juries going again.
Okay. So we won't have as many inmates coming down here.
Right. We'll still have some coming here because there's some things we need people in court for, but it'll take some of the pressure off that as well.
Okay. All right. That's outstanding.
If it works, that's what we're trying to make happen. Yes.
Judge, while we are waiting for the attorneys, can I get some mic checks with the inmates that are in the cells? If you could have the court reporter unmute the inmates, and I'm going to ask the deputies I'll call out the booth to see if they can do a mic check so we can make sure this is working before the attorneys get on board.
Okay, that'll take a second to unmute them all, but I'll let Mr. Forte get into the system, and then you want to know the booths that they're in? You're ready?
You see,
Okay.
no, I think he can just unmute and then they'll all unmute. Are you going to do them one at a time?
Well, if we unmute everything, we get a really bad noise. When we first started, they were all unmuted, and it sounded like we were at an airport, like out on the tarmac.
Okay, and
Right.
this
Shay,
is
we've got to track down what that noise was. I think right now, if we could just unmute the booths that have an inmate in them or a deputy right now and just check.
Yeah.
It would be.
So I'll call them out. You want to just write this down?
I'll call it out and we'll do it one at a time. But Captain Betts, will you let the deputies know that the doors should be closed? Like all the doors should be closed if the inmates are in. All the doors should be closed whether they're inmates or not. So that's going to eliminate some of the noise. But
yep.
If you could unmute one north booth 1 for me, and we'll do a mic check on that one first, please.
Is it easier to do a bunch at once or one at a time?
He has to do them one at a time.
Okay, so 1 north 1.
1 north 1.
And who is that? Well, I guess we'll find out. That'll be part of the sound check.
Right. This check will be the inmate will the defendant will say their name, please, when it's unmuted.
While we're doing that, Ms. Nelson, any update from Mr. Smith? Oh, here we are.
My name is Tavares Bivins. Is it okay if I use the restroom right quick, Your Honor?
Sure, that's fine. We got you. Your position 2.
Oh, thank you. I don't know.
All right, that was a good sound check. He sounded good to everybody, at least to me. Did he? Everybody else?
I wanted to ask him, could he hear us pretty good? But obviously he could. The next one is well, I don't have anybody there. The next one is anyone in 7 in there with you, Captain Betts? I don't see anybody. Do a sound check on 7 South Booth 1.
I was gonna say, Shay, you can get Betts to just speak into the mic to see if we can even hear him.
Okay, that's a good idea. 7 South Booth 1, please. No, it's not.
Hold on, you have to be unmuted first.
There you go, right there. Let's see.
Okay, can you hear me, Shay?
No.
Can you hear?
That's Mr. Hartnett.
Yes, Your Honor.
Great.
Can you hear us okay?
Maybe if they
Yes, ma'am.
maybe if they close that door, you won't get that feedback.
It would. That's right, Willie.
So you gotta close the door.
Close the door. Okay, say your name again, sir.
My name is Sanchez Hartnett.
Is that okay for you, Judge?
Yep.
Okay, thank you.
Yeah, that sounds much better when the door is closed.
Yeah,
You don't
all
get
the
that
doors
echo.
need to be closed all the time.
Okay, 2 South Booth 1. So Judge, on my documents, who's muting and unmuting? Is it the court reporter?
Yes.
Right now it is, just because Mr. Forte's, he's got a little device in front of him that lets him do it, and Isaac trained him on it about 10 minutes ago.
Yeah, he got 10 seconds of training.
Yeah, but we'll need to figure out a way. Well, it'll be a little less problematic when one judge has only one set of booths. This is a million little screens. But we do need to come up with a way to control the microphone and ideally the camera. This is going to be the same process in each of the booths so that we can just have up and live the booth that we're using. Yes, sir.
Your name, please?
Thompson.
This is problematic, Mr. Standard. There's a lot of background noise.
Looks
Well,
like,
he just
closed when he closed the door.
Yeah. All right, Mr. Thompson, we'll get back to you soon, okay?
Okay, thank you.
All right, let me look at 2 South Booth 1. Something else.
I don't see anybody else.
We've got 7 South 1. That's it. We should have 3 more. One is a female, so that could be, we've got someone at Union City, and I noticed we've got a deputy. There we go, South Annex.
South Annex, yes.
That's a little different. Are you able to find South Annex? Yep, she's waving. We see you.
South Annex, not South Tower, right?
Yep, South Annex.
See Jimbo, Rice Street, and then north and South Tower.
Isaac, where should Carl look to find South Annex in your secret screen?
Oh, goodness. South Annex? No, we don't have anything.
No, they won't be there. They will have to unmute and mute that device at Union City.
Oh, okay. They just did. There it is.
That's the old school.
Okay. Are you Miss Perkins?
Yes, sir.
Great. We'll get to you soon. Stand by.
Okay, thank you.
You're welcome.
And Judge, it was on our agenda to equip the Union City facility with a booth as well later on. We haven't done it yet.
No, and that is a much lower volume, so we're good. It's good to test it out, but it sounds like they'll just have a deputy do that. So we're missing Tobias Brown and Bruce Wallace. Oh, someone's waving there. So 1 North 1? 1 North 1. And then it's going to be 2 South 1. But no, we already had someone in 2 South 1. That's the guy who had to go to the bathroom. No, maybe that was Bivins. So 1 North 1.
Excuse me, Your Honor.
Yeah.
For position number 6.
Mr. Wallace?
Yes, I have to run up to the 4th floor. So after I'm done with him, I'll run up to the 4th floor and get the inmate.
Okay, is this Mr. Brown?
This
Who
one
are
here
you?
is Mr. Bivins.
Oh, that's Mr. Bivins. Okay.
Yes, I have to
1
run
North
to the
1.
4th floor to get Mr. Wallace.
Okay, so Mr. Wallace is 4th floor, and you'll go up and get him at the appropriate time. How about Tobias Brown? Okay, that's 2 South. 2 South 1. Okay.
So Captain Betts, can you help me with that situation?
Wait,
The
but
1
2
North,
South is-
there should be a deputy on the 4th floor already, so why is he having to go from 1 to 4, please?
Yeah. So Ms. Alexander, do you think it's okay if I drop or remove so we have fewer tiles on the screen, the booths that we're not using?
You can drop, that'll be perfect. Drop because we invited, everyone's in the one, computer 1. So we can drop 2. We just
All the
need to see
2s?
them.
Great.
All the 2s, yes.
Yes.
Were you able to switch over to this other Zoom channel? Well, all right. I can't keep any longer. I just have to hope that.
All right, so those are all booth 1s, and that is much more manageable. All right, do we have Mr. Smith yet?
I'm still here, Judge.
Okay. I did. You ready? 1 is 7 South, 1. They're all 1s. So 2 is 1 North. 3 is 2 South. I think 4 maybe also, because every time I said that, someone waved from there. So they may have to do one after the other. 5 is South Annex. That's Ms. Perkins. And 6 is on the 4th floor. We just don't know where because someone was going to have to run up there and get him after they were done on a different floor. There's Mr. Smith. How you doing, Mr. Smith?
I'm doing well. How about yourself, Judge?
I'm doing well. I appreciate your agility. I didn't realize that there was a Zoom session set up for these cases from Justice LaGrua's former docket. And so we set up all these booths that you see on the screen where the defendants will be able to connect with us using the Zoom session that Ms. Nelson established this morning for my hearings this morning, and we just extended it to the afternoon. So you and the lawyers were all in the right place. It just was the wrong place. So I appreciate everyone's agility in bouncing over here. We're a little behind, but hopefully we can catch up. I've got a calendar with 6 positions on it. We're going to go in the order of the calendar unless someone has agreed that we're going to go in a different order. I know out at the jail, they've lined it up so we can start with position 1, which is Mr. Hartnett. And my understanding is that the first couple positions are bond hearings. Then we've got a plea, a bond hearing, and then ideally 2 more pleas. Is that your plan, Mr. Smith?
Yes, but with the drawback, we do have a young gentleman that is on the work hour, and Mr. Meters will definitely chime in on that, just to kind of let you know the situation.
May I be heard, Judge? I'm Alan Metters for Mr. Bivins, number 2 on the bond.
Okay.
That's all right. We're fine with number 2 now. The gentleman had to go back to work. He works for the city of Atlanta, and he had to go back to work. He took all the time off he could take to go sit in his car for this matter.
Okay, well, I will certainly factor in that there was someone who took a chunk of his day off to say something on behalf of Mr. Bivins.
Okay, thank you. Thank you, Judge.
You bet. All right, so we're going to start with Mr. Hartnett, and that is 7 South 1. We have to, from our end, activate the microphone in these booths. So we're going to do that now. Mr. Standard, one other observation I've got for your project out at the jail is some of the glass needs to be cleaned.
Understood, Judge. And deputies, we got to keep these doors closed.
All right. Hopefully we can get this to work. So who represents Mr. Hartnett? I've got an attorney, Jerome, representing Mr. Hartnett. Mr. Smith, was he plugged in on the other Zoom call?
Yes, Judge.
All right. Well, hopefully he made the transition.
I do not see the name, but he was on the previous Zoom call.
Well, we will come back to him. Mr. Hartnett, don't panic. We're going to figure out where your lawyer went, and we're going to go to position 2, which is Mr. Bivins, Mr. Metter's client.
Yes, thank you, Judge. Is Mr. Bivins?
He's not live yet. I mean, he's alive. It takes a minute to toggle the microphone. So I'll let you know when we're ready because I'll call the case.
All right. May I sound from Ms. Bolton? I don't know if she was on, but she may have had to leave as well.
Once we get started, you can.
Okay, thank you, Judge. Oh, there she is.
Oh, I didn't tell you where he is. 1 North 1. Sorry about that. He's good? Okay. Mr. Bivins, can you hear me?
Yes, sir, Your Honor. How you doing?
I'm okay. Thanks for your patience. We're going to get started now. This is indictment 18 SC 157892, State versus Bivins. Who is handling this case for the state?
ADA Travis Thomas for the state, Your Honor.
Good afternoon, Mr. Thomas.
Good afternoon, Your Honor.
And Mr. Metters, you represent Mr. Bivins.
Correct, Judge.
All right. So Mr. Bivins, we're going to talk about bond today. My paperwork says you have a bond right now for $35,000. Mr. Metters will set me right if that's incorrect. So he may be arguing for a reduction in bond rather than setting a bond. And it looks like you've been in jail for a couple months and almost 3 months. You're charged with 2 counts of aggravated assault and some weapons offenses. Hold on 1 second. Okay, hold on. We're pausing. Can you hear us now?
Yes, sir.
Okay. Any idea what happened? Echo. Okay. All right. Mr. Bivins, you can hear me now?
Yes, sir.
Great. All right. All I had been saying was I understand what the charges are. You've been in for a few months, and I was turning it over to Mr. Metters to tell me what he thinks should happen. Okay?
Yes, sir.
All right, Mr. Metters.
Thank you, Judge. For the record, my name is Alan Metters, and I represent Shavaris Bivins in this. Mr. Bivins was out of jail on a $35,000 bond put forward by AAA Assured Bonding. That bond is still in place. In fact, I submitted an exhibit the other day. The letter is dated February 16, 2021. That says, if I may read that, Shavaris Bivins was bonded out of jail September 25th, 2020, Jet Bonding Company, and we were not notified, Jet Bonding, of the court date for this defendant. If you need further information, please call. His bond was not revoked. What happened to Mr. Bivins was, for whatever reason, on this 2018 case, neither he nor the bonding company received notice of a court date. Mr. Bivins had been to numerous court dates on this case, this 2018 case, well before the COVID business started, numerous court dates, and it was continued. For whatever reason, the state was not ready to try the case. But then he slipped, as some criminal defendants do. He did not receive notice, not appear in court, and was arrested subsequently for failure to appear. Now, what concerned Judge LaGrua was a subsequent case, another case that cropped up, a dispute with his wife. And she called the police, and he was arrested in about August of 2020. And that's when I came and represented him the first time in August of 2020, when he received a bond for that case as well. So there are really 2 cases here.
What is the number for the other? Do you have the indictment number for the other case?
Let me see if I can find it. I've been concentrating, Judge, on this case, and
So, Your Honor, I can clear that up. It looks like that case has not been indicted yet. This is a CWAC case, so it's still open, just hasn't been indicted yet.
What's the CP number?
CP is the same that's on the calendar, Your Honor, 20 Charlie Papa 194-267. Oh, I'm sorry, 276.
All right, I don't have anything on the calendar, so tell me that again, please.
20 CP 194 276.
Thank you.
Now, the complainant in that case, Ms. Bolton, his wife, is standing ready to testify. She's on your screen, I believe, to testify as to what happened in that particular case. As I understand it, and she can testify and correct me if, but anyway, they ran into each other. They had a meeting at this Family Dollar store over off of Cascade Road, and a dispute occurred. A child was in the car, their child was in the car, and words were exchanged, and the police was called, and Mr. Bivins was arrested. That's what happened in August last summer, 2020. And then he bonded out of jail on that particular case. And when Judge LaGrua did hear a previous bond request to have this $35,000 2008 bond reinstated, but Judge LaGrua wanted to know something about this new 2020 case. And that's why Ms. Bolton is standing by to testify about that case. And I'll call her in a moment. In fact, I'll call her right about now.
Well, before you do that, let me make sure I understand. I'm still not clear. So I'm looking at the CP case, and there was a $17,000 bond set on September 24th of last year.
Correct.
And what you're saying is your client made that bond.
Correct.
And was later arrested on a failure to appear, not for that case, but for the older aggravated assault case.
The 2018 case, yes, Judge.
Okay. So I'm more interested in understanding why he didn't show up for court. And you're saying he didn't get notice, but his address must have been all over the system if he had just been in the system.
Well, we'll have to hear from Mr. Bivins precisely on why he did not receive notice, whether or not he'd moved residences, but he and his wife were in the process of separating, I believe. Plus his attorney, well, this was happened in June of 2019, his attorney, Brian Whiteside, who became the Gwinnett County solicitor about that time, withdrew from the case. So Mr. Bivins was unrepresented for a period of time, and I'll call Mr. Bivins and he can explain to the court why he did not appear, why he did not receive notice, what his living arrangements were at that time.
Well, rather than calling him, because that gets complicated, let me just ask him a few questions. So, Mr. Bivins, what is your address right now? I mean, it's Rice Street, but if you weren't in, what would your address be?
Currently, me and my wife are back together. Our address is 1045 Fair Street.
So, what are other addresses that you might be associated with?
My barber shop.
And what's that address?
It's 1380 Ralph David Abernathy.
Okay, and that's a business you own or lease. If that address, do you own it or you lease it?
I lease.
Do you get mail at that address?
Yes, sir.
Okay, that's the address that is in the system for both your cases, the indicted and the unindicted one, and that's the address that your notices to come to court will go to. You must have received notices there before because you come to court a bunch of times.
I was actually, when I was with Brian, my last attorney, Brian Whiteside, me and my wife resided at 3185 Oak Cliff off of Martin Luther King. So that's where my mail was coming to before my last attorney dropped off my case. And then after he dropped off my case, as I was looking for another attorney, I changed my address to 1380 Ralph David Abernathy. And I never missed a court date because I always call the bonding company, or they call me prior to or before I had to go to court. They'll call me and let me know that I was supposed to be in court on a certain day. But they never got a notice, and I never got a notice either around the pandemic time. So that was the only time I ever missed. But
Mr. Metters, what was the date of the event that Mr. Bivins missed?
It may have been September the 25th, 2000.
No, it was July 9th.
July the 9th, that was the first one? Okay. But it was in 2020. That was the first date, and I think there may have been a subsequent calendar in September that he missed as well.
Well, July 9th doesn't make sense because then there would have already been a warrant for Mr. Bivins in the indicted case when he was arrested in the unindicted case.
That's what I don't understand either, Your Honor.
He was arrested for failure to appear on the indicted case. The unindicted case, there's really been no activity on that I know of, except the bond hearing at the, well, the bond hearing was in September. He was also in jail and it was on Zoom.
So what I have down here is that Mr. Bivins has been locked up for a little less than 3 months.
88 days.
Right. So if I do that math, that gets us into December when Mr. Bivins would have been arrested.
I was arrested November 21st, sir.
That's pretty close. So I'll take November 21st. That means that Mr. Bivins was not in jail after the new charges were brought, the 20 CP case. In other words, he got a bond then. So someone needs to make clearer the timeline. What happened on November 21st?
November 21st, I was pulled over in traffic.
And
they said that I had a warrant for failure to appear.
Okay.
Sir?
I'm following you, but then it was failure to appear for what date?
For July the 9th of last year.
But that had already happened when you went through the system in August because of the unindicted case.
No, sir. Failure to appear didn't pop up then. It didn't pop up at all. I bonded right out of jail the next day after I was arrested.
Yes, Judge, I can affirm that. He bonded right out of jail the next day. $17,000 bond on the September.
I'm just looking at documents in the docket here. Mr. Smith, I can't find anything in the docket that would have been noticed to Mr. Bivins that he needed to be in court in July of 2020. What should I be looking for?
Just a certificate of service for a calendar court date.
Yeah, I know, but
and I'm looking also, and I don't see anything either.
There's one. Okay, something got returned to court. There was an effort to deliver mail to Mr. Bivins at 1380 RDA for this court date, and it didn't get to him. It got returned, said it was undeliverable. What was going on with your barbershop in July of last year, Mr. Bivins?
Nothing at all, sir. We was in business.
Okay, well, it got bounced back. Let me hear from Mr. Thomas, because what I see right now seems to be not a willful failure to appear. There's certainly an issue with Mr. Bivins getting arrested, for something while on bond, but that's not what Judge LaGrua signed the bench warrant for. It was for failing to appear. And there is in the docket, if you really scrape the bottom of it, evidence that the notice sent to Mr. Bivins to come to court on July 9th, 2020, never got to him. I'm looking at the screen right now that it bounced back to Judge LaGrua's chambers.
Judge, may I be heard on the barbershop?
Nope, I'd like to hear from Mr. Thomas.
Okay, thank you.
So yeah, Your Honor, so I'm seeing that too. There was a bounce back, and I'm not sure if Judge LaGrua took that into account before issuing her FTA. I'm not sure what evidence or what information she had on her when she did that. I wasn't here either. However, Your Honor, I'm also concerned about the new case that was picked up, which seems to be a fairly serious case. This is in one of our special units that was picked up after this. And then beyond that, Mr. Bivins also has, convictions for similar acts, aggravated assault, robbery, and burglary. So based on all that, I think there's enough on the record, even if you set aside the fact that he wasn't notified for the FTA, I think there's enough on the record to not issue a bond right now.
All right, that's helpful. So, Mr. Metters, what I'd like you to focus on then is the new charges. I don't think that it would be appropriate to decline to reinstate Mr. Bivins's bond for the failure to appear. It looks like there was some mistake and it didn't go to the barbershop. That's not his fault. It's really not anyone's fault. But Mr. Thomas makes a good point that someone who is on bond for 2 counts of aggravated assault, having a firearm as a felon, then gets arrested for another crime of violence. So why is that not a reason to revoke the bond and keep him in a no bond status?
Well, we would submit that it was not a crime of violence. It was a verbal dispute with his wife, and I would like to let the judge inquire of her, Ms. Bolton, if she could appear. Ms.
Okay.
Bolton?
Why don't you ask her the questions you want? Is that there's someone on and it says Marquita's iPhone?
That's the complainant. That is the complainant, Judge.
Okay.
That's Marquita?
Yes,
Ma'am, can you state your name for the record?
Marquita Bolton,
Standard spelling of the last name, Bolton?
Bolton.
Okay. And what's your connection to Mr. Bivins?
My husband.
Okay. All right. So Mr. Metters says that whatever happened on August 20th wasn't such a big deal. Why is he saying that?
We have since then resolved the issue. It was not a big deal as far as that where I wanted him to be in jail. We have kids together, kids we have raised together, and he also has kids that he needs to be out for. He's a good man. He works, come home, that particular day we just had a bad heated argument, which went a little too far between both of us. And since then, apologies, we both apologized and things have gotten better. So his family needs him, he's a good person at the end of the day. All that stuff that they were saying, that's old. I don't know nothing about that. I've been with him for 6 years.
So when you say it went a little too far, what do you mean by that?
The arguments, the calling names, as far as that part.
I'm trying to find where the actual charges are. This one. One of the things that Mr. Bivins is charged with, Ms. Bolton, is damage to property. Did he break something?
Yes, sir. It was the car windshield.
How did he break the car windshield?
He was upset.
No. Why did he do it? How did he, if I punched a car windshield, I'd hurt my hand. I wouldn't hurt the windshield. What did he break the windshield with?
He used a helmet, his motorcycle helmet.
Okay. Mr. Thomas, I'm not putting Ms. Bolton under oath. I'm not making it that formal, but are there any general questions you want to ask her about the August situation?
Just briefly, Your Honor. Good morning, or good afternoon, Ms. Bolton. My name is Travis Thomas. I'm the prosecutor in this case, so I just wanted to let you know that I am actually prosecuting this case. My question for you, you called the police during this incident, correct?
This is for me?
Yeah.
Yes, the police was called. My father called the police.
All right, who called the police?
My father.
Okay, so your father was there during the incident?
Father vehicle. Yes, he was notified about it.
Okay. That's all I have, Your Honor.
I've got one other question, and then I'll let Mr. Metters ask you questions, Ms. Bolton, if he has any. And I appreciate you talking about this. I know it's not easy to do. In looking at what the police had to say, there was an allegation that Mr. Bivins may have done something to your kids' shoes and clothes. What was that about?
When I left for work, we're not sure. We like they said, they couldn't say he did it because I don't know if they had, but when I left for work and came home, all their shoes and clothes was missing, and well, not all of them, most of them was missing, and some stuff was destroyed in my house.
What does destroyed mean?
Meaning like clothing was bleached
And that's not how it was when you left for work?
No, sir.
Okay. All right. Mr. Metters, anything you want to cover with Ms. Bolton?
Your Honor, if I could, I do have one more question.
Sure, Mr. Thomas.
So, Ms. Bolton, there's also an allegation that you may have told the police that he actually put his hands on you. Did he actually put his hands on you during this incident?
He didn't put his hands on me physically, no. No.
Okay, so during the whole incident, he never touched you?
It wasn't like that. It wasn't like a punch or a slap or nothing like that.
No, I'm just asking, did he ever put his hands on you? That's all I'm asking.
Yes, but not far as harmful. Yes.
Okay, thank you, Ms. Bolton.
Mr. Metters.
Yes, sir. Thank you, Judge. The windshield, did the car belong to your father with a broken windshield? Was that your father's car?
Yes.
Did Mr. Bivins receive a broken windshield too on his car?
No.
Okay. And you notified your father. Was your father at the scene?
Yes.
Was your father at the scene?
He wasn't there at the time, no.
Okay. All right. But who initiated the call to the police? Did you or your father initiate the call to the police? Call the police. You or your father?
What was that? My father, because of the windshield.
Because of the windshield. Okay. All right. Thank you, Judge. That's all. I would just ask that Mr. Bivins be reinstated. He failed to appear, but it was not his fault. And, the parties seem to be back together. And I would submit that he be reinstated. He's been incarcerated for 88 days. And on the underlying charge, the 2018 charge, he appeared in court numerous times.
So I have a question for you, Mr. Metters, if you know, and it relates to the underlying case, the 18 SC case. One of the alleged victims is a Tanya Fullerton, Atonya, standard Fullerton, and then an Ebony Gamble. Is it your contention that those are strangers to Mr. Bivins or people he knows?
I do not know, Judge. I do not know. They're not people he knows, but they might not be strangers either, if that makes any sense.
No, it does, but they weren't in a relationship with him in the way that Ms. Bolton is in a relationship with him.
No, sir.
Okay. All right. Mr. Thomas, anything you want to add?
Your Honor, I'll just renew my argument. Even setting aside the FTA, one of the conditions of him being out on pretrial bond is not to pick up any further felonies, and it looks like he absolutely picked up further felonies. So based off that alone, and with his history of burglary and other violent felonies, I would ask that bond not be reinstated this time and he be held until trial.
Okay. I am going to leave things in their current status. And I'm going to see if starting next week, there will be 2 grand juries back in action. And we will see if this set of unindicted charges is a priority for the state. If they have not indicted the matter after 30, 60 days, Mr. Metters, you should renew this request. I don't know if there'll be a new Judge LaGrua. If there's not, I'm happy to stay involved with the case because I'll have this institutional memory. If the state is not going to move forward rapidly with the new charges, which of course would go to the same judge, then we should talk again. But I think they provide an adequate basis to leave Mr. Bivins where he is right now. I'm not quite sure why a magistrate set bond the way the magistrate did in light of the fact that Mr. Bivins was on bond for a firearms offense when he picked up those new charges, but I wasn't there for that. So we'll revisit this if the new charges are not promptly indicted. But if they are, then I think it's an appropriate conversation for Mr. Metters to have with Mr. Thomas about how to handle both the cases when they are in the same division.
May I speak, Your Honor? May I say anything if it matters?
What do you want to say?
Your Honor, I didn't. Your Honor, I am a pillar to my community, Your Honor. I know that my priors, I know that they will follow me for the rest of my life. But I just ask you to look at my record, Your Honor, and see the big gap in my record where I made a change in my life. I have went to college. I have gained my master's degree, Your Honor. I have had kids. I have stayed out of trouble. I have not been in trouble since 2008, Your Honor. The 2018 case is you are the judge that gave me a bond on that case, Your Honor. You told me that, yes, it was in 2018, Judge LaGrua, she happened to be out for that day and you were sitting in for her. You even told me, Your Honor, that you knew how this case, or you have seen this case plenty of times, Your Honor, and you know that people do lie on people, Your Honor. I have not been in trouble. I hadn't been in trouble since 2018. Since 2008, and you recognized that, Your Honor. You said you knew that I had changed and I had turned into somebody different. Regardless of what the prosecutor was saying about my past record, I know that's gonna follow me for the rest of my life. But I just pray that you don't let that reflect on who I am now, Your Honor. I have gained a successful business, Your Honor. Every year, I give a back to school book bag drive to 2,000 kids. I give free haircuts to 2,000 kids every back to school. Every month I give haircuts, free haircuts to 300 homeless people. Every day I give discounted haircuts to veterans and senior citizens, young. I have been trying this situation with me and my wife. It was just an argument that went sour, Your Honor. She was throwing things at my vehicle and I threw some things at her vehicle. And I ended up going to jail about it, which I'm not mad at my wife. I love my wife. I love her to death. I love her dearly, Your Honor. But please don't let that reflect who I am, Your Honor. Please.
Well, I appreciate the history lesson. You're exactly right. Apparently in May of 2018, you and I were in the same courtroom and I did set the bond in the 18 SC case. I'm looking at it right now. I will tell you a second thing, which is that I wasn't considering in any way your past. Mr. Thomas mentioned it in passing that you'd been in trouble before, but I didn't want all the details because to your point, that was long ago. I'm focused on you were out on bond and then this situation happened, and it sounds like it's a little more than just you and Ms. Bolton were fussing at each other. And I appreciate it's awkward for Ms. Bolton to have to talk about it, but that's what I'm focused on, not your past. Your past is gonna stay with you, like you said, but it's not what informed my decision. It's what went down in August of last year, not what happened in 2008 or before then. So
Well, can I explain what happened in August? Or?
Not right now, but
Okay.
we're going to see what the state does. And as I told Mr. Metters, if they're not doing anything with that case, then we need to get back together again and do something different than what I'm doing right now. But I appreciate you sharing that.
Yes, sir.
Hey, and Your Honor, real quick, just to correct the record, earlier you said that these cases are being handled by the same unit. The unindicted case is actually a CWAC case, so it will be a different attorney. It will not be me.
Okay, I may have misspoken. They will be in the same courtroom. If and when the state does something with the CP case, it will go to Judge LaGrua's successor. All I want Mr. Metters to be doing is keeping track of it, because if we get into April, May, and it's not indicted, then we need to talk again, because it must not be as serious as the DA's office thought if they haven't gotten it indicted. Okay?
I don't understand. What is the CP?
It's just the unindicted case. That's the way for us to refer to it. All right, we're going to move to the next case. Thank you.
Thank you, Judge.
Thank you, Mr. Metters. Don't know. Let's find out. We need you to be this machine, but
She's gonna take it down. I'll just stay here and have this machine.
yeah.
If she wants.
Okay. Ms. Rivers, good afternoon.
Good afternoon, Judge.
How are you?
I'm doing good.
Are you
There is
going to
some-
take this down?
I've been taking it down.
Well, all right. Well, Mr. Bivins got extra bonus treatment because Mr. Forte took it down as well. We're going to
Okay,
keep
great.
Mr. Forte in here, but he's going to operate these microphones, so we're fluent there. And I'm going to rely on you, Ms. Rivers, to make the record for the remaining positions as well, okay?
Okay, great. Thank you. There is some feedback on my end.
Okay. If it gets to be too much, let us know, and we'll see if the audio is better here in the courtroom.
Okay, great. Thank you.
All right. Let's try one more time for Attorney Jerome. Attorney Jerome, are you on the call?
Yes, Your Honor, I'm here.
Great.
Yeah, the hearing's actually extended a little longer than I expected. Could you come back to me in about 5 minutes?
It may be more than 5 minutes, but we'll come back to you.
Yeah, if you could just come back to me, I'd appreciate that.
Okay. Then let's go to Mr. Thompson. I think, do we have Mr. Thompson's attorney? Yep, there she is.
Yes, Your Honor.
So that's 2 South 1. Ms. Jackson, is this a plea?
It is, Your Honor.
And Mr. Thomas, are you handling some, all, in between?
So yes, Your Honor. So I am now the ADA assigned to this courtroom.
Okay.
So I'll be handling all the cases on the counter.
And none of these is a specialized case. Great. Okay. Are you ready, Mr. Thomas, with the plea?
Yes, Your Honor.
Okay.
Are you going to put this on the counter, or do you want me to start with the litany?
I'll do it. We don't have the microphone on yet in the booth. You'll know when it's time. I won't leave you hanging.
I think it's on now.
There he is. Mr. Thompson, can you hear me?
Yes, sir.
Great. Good afternoon. I'm Judge McBurney. And for today, I'm your judge. Ms. Jackson is on the call. Can you see her?
Yes, I can.
Great.
Good
And the
afternoon.
DA handling your case is Mr. Thomas.
Good
And the
afternoon.
lawyers have told me that there is a plea in your case. Are you ready to go forward with the plea?
Yes, sir, I am.
All right, we're going to go on the record. This is 18 SC 159217, State versus Jimmy Thompson. Mr. Thompson is represented by Ms. Jackson. State's represented by Mr. Thomas. Mr. Thompson, before we can start your plea, I need to make sure that you are comfortable proceeding in this fashion. You have a right to be here in court, but you are actually at the county jail. Do you waive your right to be in court?
Yes, I do. I'm pretty comfortable right now.
Good. I want you to be comfortable. You also have the right to have Ms. Jackson sitting right next to you so the two of you could talk if there was something confidential you needed to discuss. But Ms. Jackson is in her office and you are in what we'll call your office right now. Are you okay proceeding in that fashion?
Yes, I am, sir.
If you need to speak privately with Ms. Jackson, let me know and I'll move the two of you into a private breakout space, okay?
Okay, thank you, sir.
Great. Mr. Thomas, when you're ready.
Thank you, Your Honor. Mr. Thompson, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may lower your hand. Please state your correct and legal name.
My name is Jimmy James Thompson, Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I'm taking high blood pressure medicine at the present.
Okay. And does it affect your ability to understand this proceeding?
No, it doesn't.
Is there any medication that you normally take that you have not taken today?
No.
Okay. How old are you and how far have you went to school?
I graduated from Decatur High School in 1979 and I turned 59 years old yesterday.
Well, belated happy birthday, Mr. Thompson.
Thank you.
Are you able to read, write, and understand the English language?
Very much so.
Do you understand that you're being charged with the following offenses: forgery in the 3rd degree?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, I do.
Have you reviewed the waiver of rights form with your attorney?
Pardon?
Have you reviewed the waiver of rights form with your attorney?
Yes, I have.
And did you get the opportunity to sign the waiver of rights form with your attorney?
Well, we discussed it over the telephone.
Okay. Have you had enough time to speak with your lawyer, Miss Jackson?
Yes, I have.
About the facts of your case and the circumstances known to you regarding the charges in this indictment, including any potential defenses?
I hear you.
Okay. Have you had enough time to speak with your lawyer, Miss Jackson, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
I feel like things are relevant.
And are you satisfied with her services?
Yes, I am.
All right, Ms. Jackson, do you waive formal reading of this indictment?
Yes, we do.
And do you waive any and all defects in the indictment?
Yes, we do.
Okay, Mr. Thompson, have you been arrested on these charges?
I've been in prison for the last 3 years. And there, from my understanding, Judge LaGrua took a warrant on me for the charge in 2018 and called me to court in 2008. Yes.
Thompson, we'll get, but you have been arrested on October 21st of last year on this, correct?
Oh, yeah, okay.
All right, thank you. Now, the state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
We do.
Okay. And has your attorney advised you of the minimum and maximum sentence for each of these charges?
Yes.
Okay. So the charge of forgery in the 3rd degree, the minimum is 1 year and the maximum is 5 years. Do you understand? Hold on one second. Do you understand that if you are guilty, your guilty plea is a blind plea, also called a non-negotiated plea, the state may still recommend a sentence to the court?
Yes.
Okay. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including in federal courts?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any government unit or any special conditions of
Yes,
probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that neither the court or your attorney nor the district attorney's office has anything to do with parole? The Department of Corrections or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anybody has told you.
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transfer a firearm, and the ability to obtain employment.
Yes.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes.
Do you understand that you waive any and all defenses, including any mental health offenses, by entering a guilty plea?
Yes, I do.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if a conviction of these if convicted of these charges at trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Do you plead guilty to the charge of forgery in the third degree in indictment number 18 SC 159217?
Yes, sir.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is.
Do you understand that you may have only a limited time to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
So, Your Honor, if this would put the trial of state, considers it would have proved beyond a reasonable doubt that on August 1st, 2017, here in Fulton County, Mr. Thompson walked into a charter bank in Buckhead branch and produced a check in the amount of $2,198.64 from Georgia Landscaping Contracting, Inc. The accused provided his personal information, cashed a check, and left the bank. The bank staff eventually was able to contact the account owners who say that Mr. Thompson is not an employee and that the check was not written to the accused. On August 26th of 2018, one of the witnesses went to Sandy Springs PDCID and provide a written statement and viewed a photo lineup, which that witness positively identified Mr. Thompson as a person who cashed that check. That's all from the state, Your Honor.
Okay, and share with me again what the state's recommendation is.
So, Your Honor, given all the factors into the history of the defendant, the state's going to ask for 5 years, serve 1, balance probated, and then also conditions of no contact with either the business, Georgia Landscaping Company, or the Charter Bank Buckhead branch. And then we're also going to ask for 80 hours community.
Okay. Ms. Crawford, are you on the call? Not sure who we have from probation.
Yes, Judge, I am.
I am looking at Mr. Thompson's repeat offender notice, and it shows many, many convictions. The most recent is from 2012. My question for you is, do you have any felony convictions for Mr. Thompson that are more recent than a 2012 conviction?
Judge, there's a 2018 conviction out of Cobb County. There's a theft by taking felony. I can provide you with the case number. Well, that's the charge that he's actually in on, the 18 case from Cobb County.
Okay, and you say he's under sentence right now?
Yes, until March the 8th of 2021.
So like a week and a half?
Yes.
Okay, and that's when his probation will be done, or he's got a custodial sentence out of Cobb County?
He's an inmate on the Cobb County case, and that time up will be March the 8th of 2021.
Okay, is there probation to follow it? Or he was revoked?
Stand by, Judge, it doesn't show me all of that. It just has that he's actively incarcerated on that case. Stand by for a moment.
Okay.
And Your Honor, my understanding of that was he did receive a 3-year sentence in Cobb County, and that he paroled out in Cobb County. No probation to follow that.
Okay. All right. So it sounds like since 2012, there hadn't been much activity other than this Cobb case and then the Fulton one that we're here on.
That's my understanding.
Okay.
She's correct, Judge.
Okay. Ms. Jackson, any idea why Mr. Thompson is in jail now and he's been in for maybe 4 months in connection with a 2018 indictment?
Yes, Your Honor. You know about that. So this does actually relate to the Cobb County case. Mr. Thompson, around the same time, cashed a check in from Georgia Landscape Contract Sandy Springs is the base of this, but around the same time, cashed a check from Georgia Landscape Contract in Smyrna in Cobb County. Cobb County arrested him for Fulton, and Cobb County sentenced him to 3 years to serve in that case, or very similar around the same time. Unfortunately, this happens to be in different counties, and so these are separate cases. So Mr. been in continued since 2018. He was up in Atlanta. He went to Cobb County. He was given a prison sentence. He went to prison in 2018. He paroled out on October 21st of 2020. And on that date was brought to the Fulton County Jail on this warrant. So he has been in prison all of this time. And that's why we're just now getting to this 2017 incident.
Got it. Okay. Anything you want to add beyond that?
Just that we are asking the court consider either time served or a probated sentence for Mr. Thompson. As I've stated, he's been in continuous custody now since 2018, and for very similar offenses that would have been the same case had this occurred in the same county. So Mr. Thompson is just asking to get out of custody. He's been in custody almost 3 years now, and he wants to get out, get back to work. To get a job with his family. His family's actually in the funeral business, and so he wants to actually go to school to become a licensed funeral director and get his life back on track.
Okay. And what normally when I see a criminal history like this, we are talking about a sentence that is designed to get Mr. Thompson some help with whatever the issue or issues might be that resulted in, with the Cobb case, 15 convictions, whether it's addiction or mental health or who knows what. And that is missing from either the state's recommendation or the defense recommendation. So you can understand why I'm a little leery of saying, all right, let's just get Mr. Thompson out and we'll hold our breath that we won't see conviction number 17.
Yes, Your Honor. And normally I would ask for something of that nature. However, just given the fact that he has been in continuous custody since 2018, I'm sure that Mr. Thompson would be willing to get a drug evaluation and any sort of recommended treatment as a condition of probation if the court felt that that was appropriate.
Okay. All right. If we had muted, just so everyone knows, the microphone where Mr. Thompson is. So he can hear us. I'm going to have him turn it back on, but we noticed that when we mute that, we lose the reverb that we were getting, which I assume was making it tricky for Ms. Rivers. It was making it hard for me to follow what was going on. We're going to turn the microphone back on because I have a couple questions for Mr. Thompson. Mr. Thompson, can you hear me?
Yes, sir, I can.
So you've been in jail now for almost 3 years.
Just 14 days, and I'll be 3 years.
Okay, and only a little piece of that has it been at Rice Street. Where were you? Were you in the state system for the other time?
Yes, sir, I was in the state prison system.
Okay, as a result of your sentence in Cobb County?
Yes.
Okay, got it. Why should we be optimistic that when you get out, we're not going to see more of the same? When I look at your criminal history, you're not out running and gunning, I want to be clear, but it's theft, it's burglary, financial fraud, bad checks. Why is it going to be different now?
Well, because I've gotten older and I've got wiser, and plus I gave my life over to God. And there comes a time in the man's life when you have to give up on you and let God take over. And I refuse to let anything of this world get back into my life again. I want to go back to school and get my degree in mortuary science. My family owns a very established funeral home. We are, by the way, own 4 funeral homes and 1 crematory. And I want to get out and get my life together in the funeral business. I know once I got myself established in something and not being, I went through a lot of abuse in my life. I've suffered with my parents. Both my parents died a year apart. And last year, my only child left me with no grandkids. He passed on me. And I feel like I'm in a world of my own now. And I got stronger. I've just turned to the ways of God now. I've just simply just gave up on me. And for these
have you ever been, I'm sorry to interrupt you. Have you ever been in custody as long as you were? Was 3 years your longest stay?
No, I was in custody back in 2008. I got sentenced for a burglary that I didn't commit. And I did like 3 years, 8 months, and 18 days. And the Georgia Court of Appeals reversed the conviction and gave me a immediate release.
Okay. All right. Ms. Jackson, do you waive proceeding on a copy of the indictment? That's what I've got here. I don't have the original. I have a copy.
Yes, Your Honor, we consent to that.
Okay. Mr. Thompson, if you were here in court, you would sign this indictment indicating you're pleading guilty, but you are there at Rice Street. Do you authorize me to sign the indictment for you?
Yes, sir.
Ms. Jackson, may I sign it for you?
Yes, Your Honor.
And Mr. Thomas, can I sign for you?
Yes, Your Honor.
Okay. Mr. Thompson, I find that there is a factual basis for your plea. You had, it sounds like, a fistful of bad checks from Georgia Landscape. You were trying to cash them in Fulton and in Cobb. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. Is that correct?
No one's forced me to do the plea, and so far as those checks at that time, I was homeless, and guys came up on me and asked me that I want to make some money. And when I cashed the first check, I told them I wasn't doing it no more. And if you would look at the pictures, you'll see where the guys are following me in the bank and making sure that I cashed the check and gave them the money. And I told them I wasn't doing it again. And by the way, behind 3 years into all those checks, I got $100 out of that. I got thrown out of the truck. I didn't get but 100. I did all this behind, with $100.
Well, I hear you. That doesn't make things better for the victim, of course. But it sounds like you were in a bad way. Where are you going to be living if you get out?
My cousin, Vicky Thompson, she lives on 3275 Wesley Chapel Road in Decatur, Georgia, and I'll be staying there. Everything's already been arranged. I thought I was going to parole when I paroled out in October 21st of last year. Those were the arrangements. I have my release papers with a date on it. And everything's been arranged for me to stay with my cousin Vicky.
Okay. A knowing plea is a plea where you've understood everything we talked about. Is that fair?
Yes.
Okay, thanks. You can mute it now. All right, Mr. Thompson, I'm going to sentence you in this case to a term of 5 years to serve 2 years with a balance on probation, but I'm going to give you credit for time served from the date you were taken into custody. So I'll need to get that from Ms. Jackson because you've been in nonstop. I don't think it makes sense to extend the amount of time you've been in. While Cobb didn't sentence you for the Fulton check, you've done 3 years, which is more than I suspect you'd get for just the Fulton case. But I am going to want you to be on probation for a few years because you're promising a lot that you're going to change your ways and you're walking with God. And I hope that's true because you don't want to lie about something like that. But the reason why you're going to be on probation is 1, to do some community service. But 2, it's going to give all of us involved here some tools to work with if things don't go well on probation. So it's a sentence of 5 years to serve 2 with the balance probated with credit for time served from what date are we looking at, Ms. Jackson?
I can state that he has been in state custody in prison since November 19th of 2018 up until—
That'll work. So credit from November 19th of 2018. So if you do that math, you've already done your 2 years and you should get out in the next few days. It'll take a little while for the paperwork to work its course. It'll be a special condition of your probation that you complete 80 hours of community service. You will need to stay away from Georgia Landscape Contracting. And I'm not gonna make you stay. I don't know that that bank even still exists. I am sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Thompson, is that while you're on probation, if you have a little problem, you and probation will work it out. But if it's a big problem, you get arrested again, you get to be hard to find, you're not living where you're supposed to, that'll come back to me to work through with you. You will need to submit to a drug and alcohol abuse evaluation. And if the expert who conducts that recommends that you follow any treatment, whether it's going to meetings, get counseling, you'll need to do that. I'm going to require that at least initially you reside at that address that you just shared with me. I'm going to put you and Ms. Jackson in a breakout room in a minute with the probation officer so that she can get all that information, and she's going to give you reporting instructions. Ms. Jackson will get those reporting instructions as well, so you can always call her if when you get out you don't remember what the specifics are. Any questions about anything I just said?
No, sir, I'm just ready to go on with my life.
Okay. Mr. Thomas, anything you want to add?
Nothing else from the state, Your Honor. Thank you.
Ms. Jackson?
Nothing else, Your Honor.
Okay, I'm going to move the three of you to a breakout room. Ms. Jackson, when you're done with that, you are free to go.
Thank you, Your Honor.
Hold on one second. Jackson, Crawford, let's see, 2 soundproof 1.
Thank you, Jesus. Thank you, Jesus.
I can't add him.
Oh, thank you, Jesus.
Yeah, and I can't do that. So cancel. Strike that, Ms. Jackson. I am not able to add booths to breakout rooms. That's not a feature we've got. So Ms. Crawford, do you want to engage here?
Yes, Judge. Mr. Thompson, I'm Ms. Crawford from Probation. I need to get an address from you and give you your reporting instructions.
Okay, the address would be 3523 Wesley Chapel Road, Decatur, Georgia, 30034.
What county is Decatur in?
DeKalb.
Okay, so I'm gonna give you your reporting instructions to report to DeKalb County, or do you already report to Cobb County?
I don't report anywhere.
Okay, I'm gonna give you your reporting instructions for DeKalb County.
Okay.
You're gonna have to have somebody to write it down, or maybe your attorney can write it down for you. But your report date will be Tuesday, March the 16th. That's gonna be at 9 a.m. The address is 2910 Miller Road, Miller Road, Suite 150 in Decatur, Georgia. Do you have an emergency contact, like a mom, sister, somebody that I can write down to get in contact with you?
Yes, Pamela Thompson.
What's that relationship to you?
My sister.
And her telephone number?
678-480-6649.
Okay, do you have any questions for me?
No, my heart's overwhelmed right now. I can't think of anything.
Okay, if you have any questions, just contact your attorney and she'll reach out to me.
Okay, thank you.
Thank you.
All right.
All right. Thank you, Ms. Crawford. Thank you, Ms. Jackson.
All right, you have a blessed day. Thank you, Mr. Browning.
All right. So let's see if we can go back to position 1. Mr. Jerome, you back? All right, you're muted. So that's 7 South 1. And Ms. Rivers, when we are doing that exchange with probation, you do not need to take that down when Ms. Crawford is getting the information. You don't need to worry about that.
Okay, understood.
All right. Can you see me?
Yeah,
Can
I
you
can
see
see.
me?
Can you see me?
Yeah. All right. You can hear me also now.
Yep. We got both.
All right. All right. Let's go. I'm ready, Your Honor.
Okay. We're waiting on Mr. Hartnett. We gotta make that booth come live.
Judge, the defendant in 7 South, booth 1 is trying to get your attention.
Yeah, we're trying to turn it on. We're about to start it.
Thank you.
Your Honor, and I also submitted a document here. I've only sent it to Mr. Larry Smith. I don't know if he could forward that to you. And if I could get Mr. Thomas's email address, I'll forward him also. It's just a
I
positive.
can't hear anything.
Mr. Hartnett, can you hear us?
I can't hear you guys. I can't hear anything.
Can you hear me now?
Oh, yeah, yes, sir. Yes, sir.
Okay, we had a little issue here, but we're back on it. All right, let's go on the record. This is position 1. It's case 17 SD 149610, State versus Sanchez Hartnett. We're here to talk about bond. I've got a lot of education to get from folks because I've got down here that Mr. Hartnett's been in for 3 years. He's wearing a red jumpsuit, which tells me he is not from Rice Street right now. And so I'm going to let Mr. Jerome orient me as to what we're working on. And I will gladly listen to what both sides have to say.
All right, Your Honor. Yeah, Mr. Hartnett is actually, he was actually arrested on September 6th of 2016. At that time, he also was violated on his probation. He had a probation violation hearing. I believe that you presided over that hearing. And he had 2 years remanded from his probation. He served those 2 years and he has returned to Rice Street, and he's been in Rice Street for the past 737 days. He's been incarcerated for a total of 1,632 days, roughly 5 years and 4.5 months here.
So, Mr. Jerome, let me make sure I follow that because the name was familiar. I knew Mr. Hartnett and I had interacted at some point. So I heard a probation revocation hearing revoked 2 years, but since he has served those 2 years, he's been sitting at Rice Street for 3 years?
He's been sitting on Rice Street, Your Honor.
Okay, why is he still wearing the red outfit? Is that?
I'm not exactly sure. That's actually something with the jail. I'm not sure why they still have him in the red.
Okay, and he can explain that. I'm not making a big deal out of it other than it usually says to me that he's visiting us from a state institution, but you're saying his state time is long since over and he has been now been a county inmate solely on these 17 SC charges.
Yes, right now he's just a county inmate on these charges.
Okay. And you're saying it's high time he get a bond?
Yes, Your Honor.
All right, and why is that?
So, as I said before, I don't want to get into the case too much here, into the facts of the case here, but it's just not, there's not a likelihood that Mr. Hartnett is going to be convicted of these charges. Mr. Hartnett is currently positive for COVID. I forwarded a COVID test that I actually went to the jail and received from the medical department there, that he tested positive for COVID on February 17th of this year. I also filed the same motion last year. And so I don't know, I guess you can get it more than once, but he's positive right now. And he's been suffering dearly because of it. Yesterday, one of the issues he was telling me about was that he was having issues sleeping because he feels like he's suffocating in his sleep. He can't even breathe properly while he's sleeping. And we already know that COVID is a major issue, not just in the state, but throughout the country right now. And jails, federal and state, have been making every effort to follow the CDC guidelines in terms of social distancing and making sure that everybody has proper PPE. However, it's impossible to do it within a jail that is such a close confinement with everybody in such close proximity with together. At this point, Mr. Hartnett has already served more than a sufficient amount of time. We're talking about over 4 years. We're talking about close to 5 years now. He's been incarcerated and he doesn't even have a trial date in sight yet. So we're just asking that he be released on bond. He's going to be going to his mother's house, who lives within Fulton County. She's going to be taking care of him. She's actually in the courtroom right now, and she would like to speak on his behalf in a moment here. But he's going to be going to her house. Mr. Hartnett is open to any remediation measures the court feels that it may need to take in order to assure his appearance. However, Mr. Hartnett does not have a history of fleeing from the police or a history of failure to appear here. So we don't believe that appearing for court is going to be an issue. Mr. Hartnett has not made any attempt to intimidate the witness in this case, and he has not shown any propensity to commit another felony here. So we're just requesting that he be granted a reasonable bond and be given the chance to heal and, you know, survive this disease that he's caught at home with his mother. His mother's here and I can't see the courtroom clearly.
She's in court. I can see her. She's waved. She's actually been here quite some time as we've been working through our technical issues. So I'll hear from her in just a minute. She's holding a very small child. So I'm anxious to let her get on her way. So you and Mr. Hartnett should know that his mom has been here the whole time. Do you have the case number, Mr. Jerome, for the case for which Mr. Hartnett was revoked?
I do. Give me one moment here, Your Honor. All right, that case is 14 SC 124646. Let me just make sure.
Okay. And other question I've got for you, Mr. Jerome, before I hear from Mr. Hartnett's mother is, are you ready to go to trial with the 17 SC case, the case for which Mr. Hartnett is currently being held?
We are ready to go to trial. There's only one, there's two pieces of evidence here. The state had made a subpoena for some Instagram information. I also made the same subpoena to Instagram. I believe that theirs was served, however, mine was not. I would like to get a copy of those. There's also a tape from the gas station that I have not received. And receipts. There's some receipts that are in question here as to the items that were actually taken, which don't actually exist, but the state claims to have it.
So it sounds like things to which you are certainly entitled, but not things that if you got them, you would suddenly say, uh-oh, it's a completely different case. In other words, you're ready with your defense, about which you sound very confident, but you certainly want these other things. Is that a fair statement?
Well, Your Honor, the Instagram messages are integral to this case. And so I would like to be able to get those also. But okay. Yes, I mean, we are ready to go to trial.
Okay, I'm not putting you on the spot other than part of what I'm factoring in here is when could Mr. Hartnett get a trial? It's a one defendant case. He's been in jail longer than most folks over at Rice Street. And we are actually starting to do trials just like this one in 2 weeks. A single defendant case that could be dealt with in a week. So that's why I was asking if you were to tell me, gosh, the state still hasn't given me these 100 things and there are witnesses flying in from Thailand, that would make it different. Okay, let me, I don't really want to make mom come all the way up to the podium unless she's got something to say beyond, he's a good kid and he can stay with me. Is that basically the essence? You support your son and you would be willing to make your household available for him to live at? Okay. So mom very much wants her son home and she would make her house a safe space for him to stay at. Ma'am, would there be other people in the house besides you and a little one there?
We also have a 15-year-old sister that lives with me as well. This is his baby sister, we met to the baby sister, but she stays in her own.
Okay. So for the record, what I heard from Mr. Hartnett's mother is that in the household, along with Mr. Hartnett and his mom, would be his daughter. Oh, his sister and his niece and maybe one other sister.
He has a son that's 7, and the son normally comes with me as well.
Okay, and his son might be there. I was just asking to make sure it wasn't a house where there was going to be lots of trouble for Mr. Hartnett. It sounds like he'd be the trouble there and not all the other people who live there. Okay, got it. Was there anything else, Mr. Jerome, you wanted to make sure Mr. Hartnett's mother conveyed to me?
No, that's it, Your Honor. And she also says she's going to be taking care of him while he has this COVID.
Okay, well, she's got her hands full, but it's good to know if in fact he's got it a second time that she'd be willing to care for him. All right, let me hear from the other side. Mr. Thomas, your thoughts. Oh, one more thing. The case number, I must have gotten the wrong case number from you. 14 SC 124646 is not unless your client also goes by Elisha Waters.
Okay, let me double check that. Hold on a second.
Okay, you look that up. Let me hear from Mr. Thomas.
And Your Honor, it says 646, try 626.
626. And he may have said that, and I may have written it down incorrectly. I'll look that up while you're talking to me.
So yes, Your Honor. So this is a case, the alleged facts in this case is there was a transaction that started over the internet, basically shoes and apparel. There were a few successful transactions, and then all of a sudden one transaction turned into a robbery with, Mr. Hartnett allegedly producing a weapon, and his co-defendant also producing a weapon. And the one of the troubling things about this case is that the victim was able to leave. He hopped in his car and left. However, after the victim hopped in his car and left, allegedly, Mr. Hartnett followed the victim in his car and continued to brandish a weapon and intimidate the witness. So that's one of the things about this case that is fairly concerning to me. Now, if you look at Mr. Hartnett's history, he has a considerable history over like the last 10 years. And Judge, you know about this because you said in one of his cases. And when you granted him, when you had a bond hearing for him, you noted in your opinion that it was a concern that he at the time had 5 open cases. So as we stand here today, we're looking at 1, 2, 3, 4, 5 cases where he has pled guilty within the last 10 years or so, including 2 of them being burglaries. The other ones were either misdemeanors or drug charges. What we're looking at here is definitely somebody who's a recidivist, somebody who does have a history of theft and robbery, and that's the same thing we're here for today. Now, Mr. Jerome mentioned that one of the factors of Mr. Hartnett still being in jail is that he needs to get out of jail is COVID, and I definitely agree COVID is an issue, but as the court knows, COVID is part of the reason why we haven't had jury trials in a year. So I would ask that you take that into account when thinking about the amount of time he's been in jail. We haven't been able to have a jury trial in a year. As far as us being ready for trial, to be honest with you, I've been in this unit for like 3 weeks. Haven't had a chance to go through the file. I'm fairly certain I can be ready for trial if the trial is set. However, I cannot give you an accurate picture of where we are because I haven't had a chance to go through the file. I noted down the items that Mr. Serge was saying that, or Mr. Jerome was saying that we're missing. If we have it, I'll get it to him. If we don't have it, I'll figure out why we don't have it. All that to say this. So Your Honor, we're looking at someone who's been in jail for a while, has a history of pleading guilty to burglaries, has 2 burglaries, fairly recent, and is now facing an armed robbery, which the state sees as an escalation, as opposed to just more of the same. Based on that, Your Honor, I would ask that no bond be given in this case, specifically because of the possibility that, you know, he's picked up so much in a short time, and there's a good, you know, based on prior acts, there's a likelihood he could pick up more. Your Honor, if you are inclined to grant bond in this case, I would ask no less than $50,000 bond in this case, because of, you know, the history, and also because of the likelihood to reoffend in the future.
Your Honor, may I reply?
Sure. No, I always end with the movement. I just was refreshing my recollection as to what this case is about. I actually had a mini trial on it, Mr. Jerome, and I think you're right. You do need the Instagram materials because this one was not a particularly close call as to whether the state proved by a preponderance, so it's not a jury trial, but by a preponderance that Mr. Hartnett had violated the terms of his probation in his 4 open cases by getting involved with this case, the one that you have. So it's a funny way life flows that Mr. Hartnett and I are back together again. I did not volunteer for today's calendar, but here I am. And now I know why that name was so familiar. What did you want to add?
All right, so, you know, amongst the things that Mr. Hartnett has been charged with, 3 of them are gun charges. There has been no evidence of any gun being produced. And that's why the video from the gas station is so important, is because that video will show definitively that there was no gun at that, you know, at this entire encounter, and which is what the majority of the state's case is based off of. In addition to that, there was no evidence that anything was taken. Now, there was clearly a dispute and a fight. That's what everybody knows. That's what all the witnesses testified to. But everything else is only testified to by a single individual, which is the victim in this case. And it is, you know, it is incredible to say the least. It's mostly made up, and it is not supported by the other witnesses that did see them fight. Mr. Hartnett did not follow him. He followed Mr. Hartnett. Now, there was a dispute in terms of the items being sold. He was passing them off as authentic when in fact they were not. And there were, you know, and I don't want to even get into the facts of the case necessarily, but I just want to make sure that we're clear on those, you know, specific items. So I understand that there is a history here to consider. I understand that, you know, that you've already heard most of the evidence in this case, but Mr. Hartnett does enjoy the presumption of innocence at this point in the trial. He has been incarcerated for 1,632 days. And I think that it's only fair at this point to allow him a bond. And even if this does go to trial, Mr. Hartnett, I mean, and to be honest with you also, Your Honor, Mr. Hartnett is very close to the recommendation that the state was given previously on this case in terms of the time served. So, you know, that is also a possibility. I'm glad that I know that Mr. Thompson is on this, because I kind of gave up back in December trying to figure out who I needed to speak to, because no one was available in terms of discussing a plea in this case. So, you know, with all that being said, I think that it is reasonable for Mr. Hartnett to receive a bond at this point. And if you feel like there is any apprehension whatsoever, he's willing to, you know, he's willing to submit himself to any mediation measures, including a curfew or an ankle monitor, if you find that that is necessary.
Okay. Mr. Thomas, how long do you think it would take you to get to Mr. Jerome? And Mr. Jerome, how long have you been on the case? I know you did not represent Mr. Hartnett when we were handling the probation revocation. That was Mr. Citronberg at the earlier version of this indictment. The state had it re-indicted, and they added a few defendants who they contend obstructed justice and threatened the alleged victim in this case. How long have you been representing Mr. Hartnett?
So I've been representing Mr. Hartnett since about February of last year.
Okay, so you've been on for a while, during which time nothing happened with the case. largely due to COVID, but none of that is Mr. Hartnett's fault or yours, Mr. Jerome, or the state's. Mr. Thomas, how long would it take you to?
Your Honor, to be honest, a more reasonable offer would have closed this case out long ago.
Well, that's in the eye of the beholder, I guess, as to what's reasonable. And I'm not going to get in the middle of that. Mr. Thomas, how long would it take you to get the things that Mr. Jerome is missing to him?
Your Honor, assuming I have it, I could possibly get it to him by the end of the week.
Okay, how long will it take you to figure out if you have it? Some of it you ought to, because I know I saw a lot of Instagram stuff during the revocation hearing.
Yes, Your Honor. So I have like a foot locker full of evidence in this case. So I would have to go through it and figure out, what needs to be handed over. So I would ask at least maybe like 2 weeks so I can go through it and figure out what needs to go. And then within that 2 weeks, I can go through the evidence and possibly have an offer for Mr. Jerome.
All right, and I'm going to forward an email to Mr. Thomas that's going to specify exactly what we want. We're not just talking about posts, we're talking about messages from Instagram. But I'm going to forward an email to you that'll specify exactly what we believe is still missing here.
Okay, so here's what I'm going to do. I am going to set a bond. I suspect it may be a bond that is beyond Mr. Hartnett's reach. I don't know that, and we'll let the family do what they can do. But if we get a few weeks beyond today and the discovery has been provided and maybe Mr. Jerome and Mr. Thomas have had a chance to talk about the case and there's still an impasse, then I'm happy to reconvene to talk about whether the bond ought to be reduced. I am anxious, as I'm sure everyone is, to get resolution for Mr. Hartnett, whether it's a jury saying guilty or not guilty, or a plea, which would provide a little more certainty. But we do need to move the case along. Mr. Thomas is operating in a little bit of a vacuum in that there's not a judge who's going to be calendaring things, but there is the skeleton of a team in place that he could turn to if this is a case that he thinks ought to get on one of these trial calendars that we're standing up to handle cases, like I said, that really fit this profile. A real old case, one defendant, and it's not going to resolve short of trial. Maybe this one will, based on some of what I've heard between the two attorneys. But in light of the amount of time Mr. Hartnett has spent in custody, really as a result of this case, and I appreciate Mr. Thomas's observation, it was a revocation on a bunch of open cases he had when these new charges came, but we're now sort of 5 years into that. I will set a bond, and I want to make sure I'm covering the waterfront. He's got 4 counts. So on count 1, armed robbery, it's a $40,000 bond. Count 2, aggravated assault, it's a $10,000 bond. Count 3, which is firearm during commission of a felony, another $10,000. And count 8, which is possession of a firearm by a convicted felon, it is $15,000, which should be a $75,000 bond. That's a good bond. Mr. Hartnett would need to wear an ankle monitor. He would be required to live with his mother. And Mr. Jerome, you'll need to get that address to Mr. Smith, the litigation manager who will be putting this bond together. But that will be a condition that he reside at that address. And he will need to have an ankle monitor. And he'll need to have no contact with either Ms. Atchison, co-defendant number 1, or Mr. Adams, co-defendant number 2, while he is on bond. As I said, if that's a bond that is something Mr. Hartnett and his family cannot make, we should reconvene in about a month. That will mean that Mr. Jerome has had a chance to get that discovery, and he and Mr. Thomas have had a chance to discuss what they think ought to happen with the case. Mr. Thomas, any other conditions you'd want to see on that bond?
Not this time, Your Honor.
Mr. Jerome, anything else?
No, Your Honor.
Okay, can we turn Mr. Hartnett's microphone on? Mr. Hartnett, any questions about what we just talked about?
No, sir, Your Honor. No, sir.
Okay, that's what we're going to do. Thank you.
All right, thank you, Your Honor.
I need 1 second before we turn to Mr. Brown ought to be next. I don't know if we have his lawyer, Brandon Lewis. We do. There he is. All right. I need 1 second before we do that.
All right. May I be excused? I'm good.
Yes, sir. Thank you.
I can go to, Your Honor?
Pardon me?
I'm good. I said.
Yeah. Someone should come get you.
All right. Say 10. I'm done.
Okay. Let me turn back on. Let's turn Mr. Brown on for the start. See if we get that kind of feedback. Hey, are you Mr. Brown?
Yes, sir.
Hey, Mr. Brown, I'm Judge McBurney. We're going to talk about bond in your case. Mr. Lewis, your lawyer, is on. It says Prophecy 414. Mr. Thomas is the prosecutor handling your case. We're going to go on the record now. Ms. Rivers, you still good?
Yes, I am, Judge.
Okay. This is 18 SC 159511, State versus Tobias Brown. You're charged with burglary, and paperwork I have says you've been in jail for about 4 months now. Mr. Lewis, why don't you tell me what's going on with Mr. Brown and why you think he ought to get a bond? We can't hear you. It doesn't say mute, but we can't hear you. Any luck? All right, we'll give him a minute. If that doesn't work, we will go to Ms. Perkins next and see if he can sort that out, but we'll give him a minute. Mr. Lewis? You can hear us, but we can't hear you. Okay, well then bond is denied. Just kidding. Just kidding. We're gonna give you a chance. You wanna, should we do one other position and you wanna do some technical stuff? Okay. So don't panic, Mr. Brown. We're gonna figure this out. And I'll tell you, if for some reason we cannot work out the logistics today, we'll get you back on a calendar soon to talk about bond. Mr. Lewis is not abandoning you. He's having a technical issue. So I'm going to mute your microphone and we're going to turn to Ms. Perkins, assuming we've still, there's South Annex and there's Ms. Clark. Let's test your microphone, Ms. Clark.
Good afternoon, Your Honor.
Good afternoon. I can hear you. Excellent. Let's get on the record with position 5. This is 19 SC 166817. Ms. Perkins, can you hear me?
Yes, sir.
As I understand it, you're going to be entering a plea today. Is that right?
Yes, sir.
Okay. Ms. Clark, are you in a good position now? I know you've been waiting for a while, so you may now be moving to the right spot in your house or your office.
I've moved to prevent the sun from streaming in through the window, but I'm good, Your Honor. Thank you.
Okay.
Ms. Clark,
You're real quiet.
I'm
having
a hard time hearing Ms. Clark. I'll speak up. Is this better?
Yeah, you're gonna have to really speak up because Ms. Rivers in particular needs to hear you, but you're much quieter than the other folks.
Understood.
Is this a negotiated plea, Ms. Clark?
Your Honor, it is. I just sent Mr. Thomas a chat about maybe an hour ago concerning the first count. Mr. Whitenauer and I had discussed it, but it was not in writing. So the first count charges Ms. Perkins with home invasion. And so the armed robbery is being reduced to robbery, but we were asking for a dismissal of count 1. So I'm just waiting for Mr. Thomas to say what will happen with that count.
Okay.
But the sentence and everything else is negotiated.
Mr. Thomas, what's the plan with count 1?
So Your Honor, I wasn't aware that any of these charges were dismissed or any conversation was had with another attorney to dismiss these charges. So it was my understanding we were going to go forward on all charges today. And also it would be armed robbery. If it's possible, can I get in a breakout room with Ms. Clark to discuss real quick and see if we come to understanding?
The sentence
Yes.
for 2 commuted time served, so it couldn't be armed robbery.
So what I'm going to do is move the 2 of you to a breakout. You 2 can go to a breakout room. I cannot move Ms. Perkins to a breakout room. So why don't I move the 2 of you to a breakout room? Before I do that, Mr. Lewis, you're now not a prophecy, you're a galaxy. Can we test your audio?
Can you hear me, Judge?
Yes. Great. The one problem with moving Mr. Thomas to a breakout room is that puts us all on hold because we need him for all the other events. So maybe what you could do, Ms. Clark, is send something to Mr. Thomas while we go back to do Mr. Brown now that we've got Mr. Lewis on, but you could write something up and send it to him so he can be looking at that maybe when Mr. Lewis is making the pitch for Mr. Brown. And then we'll come back to Ms. Perkins, okay? All right. Sorry, Ms. Perkins. We're going to go back to Mr. Brown and go forward.
Okay.
Thanks. All right. Ms. Rivers, I appreciate you being nimble. We're going back to position 4, which is 18 SC 159511. And Mr. Lewis, you're going to tell me what's going on with Mr. Brown and why he should get a bond in this burglary case.
Yes, sir. Mr. Brown is 39 years old, and as the court has stated, he's been incarcerated for 4 months. And essentially what happened was he is in jail on an FTA. I believe at some point he was actually granted a bond, a signature bond in an amount of $11,500 on the bond on the charge of burglary. But what happened was that he missed a court date. Mr. Brown had been residing with the mother of his children for over 13 years. At some point last year, they broke up. He moved. For some reason, Mr. Brown thought it was more appropriate, instead of doing a change of address with the court, he simply did a change of address with the post office, which is not always the most reliable way to change your address and have information go from the clerk's office to where he currently resides, which would have been with his mother. And that address, Your Honor, is 2062 Beecher Road. That is in Atlanta, Georgia. That is 30311. At that address, if the court were to graciously grant him a bond, that's where he would reside with his elderly mother as well as his uncle. Judge, we're asking the court to set a bond for him for several reasons. The first is we don't believe that we're going to be able to get to this case as far as trying it anytime soon. The reason for the FTA was his fault. We granted it is his responsibility to apprise the court of where he is residing, but it wasn't purposeful that he was trying to avoid the court date. And at some point, a court thought that it was appropriate that he had significant enough ties to the community to grant him a bond in this case. Judge, Mr. Brown does have some health issues, and these health issues are properly documented at the jail. He does have significant asthma. He uses what's called a rescue inhaler and has to have that in the near vicinity of him. And during this time, he also is one of those individuals who has caught COVID, but he is one of those individuals who are in the high risk category, both having severe asthma, high blood pressure, and requires the use of what's called an albuterol breathing treatment, which is a little bit bigger than an actual inhaler that he's required to have. Now, at the jail, Judge, he is a trustee, and although he does receive nominal pay, certainly the jail, because of his character, they don't feel that he is someone who would do harm to anyone else or be a flight risk or try to escape. They have designated him with that trustee figure. Your Honor, if a bond is made in this case, it's going to be pretty much a group effort from all of his family members. He is from Atlanta. He is born and raised here. His sister, they're the only two siblings that are left, Miss Andrea Wood. She will be the individual who will be responsible for making the bond. If it's a property bond, they would be using the home of their mother to make that property bond. And as such, he's not going to put in jeopardy the home of his mother, the home of his elderly uncle, as well as the finances of his only sister who works two separate jobs. So Judge, we're asking the court if the court will grant him a bond in the amount of $5,000 that would assure that he'd come back to court and deal with these charges appropriately.
So, Mr. Lewis, I followed all that. I got a couple questions. The address of record for Mr. Brown is the address you gave, the one on Beecher Road. Why would that be in the system if you're saying that Mr. Brown used to live somewhere else and then he moved, and the way he provided the updated address was through the post office rather than through the court?
Well, Judge, it's my understanding that that address was changed once he was incarcerated.
Okay.
Yes, sir.
When he gave his address at the jail, that would have been pushed into the system.
Yes, sir.
Okay. It's interesting. It's a direct indictment. And so the docket is very, very spare. It's not clear to me that there was ever a bond for Mr. Brown for the indictment. Maybe when there was a complaint and there's no CP number that I can find on the indictment. And so this strikes me as one of those cases where Mr. Brown may not have known he had been indicted. It was a direct indictment that came very soon after the alleged incident, same month, May of 2018. But again, it's a direct indictment. And then there was the failure to appear in June, maybe, and then nothing happened for a bunch of years. And it sounds like this caught up to Mr. Brown. He must have had some contact with law enforcement late last year. And there was this failure to appear. Do you have any information as to what his bond originally was?
This is information that I'm receiving from his family. They believe that he was given a bond at some point, but it could be that he was never given a bond, and that he had a bond on some of the other charges, and they believe that there was a forfeiture of the bond because he failed to make a court date. They may think he had a bond just from that reasoning. So, but he may not have ever had a bond on that, Judge.
Okay, I'm looking at his booking number, and well, there's a forgery. There's some other stuff rattling around out there. So he may have some unindicted charges that led to his getting picked up.
I
Why don't
do
you
know
tell me,
that-
Mr. Thomas, what you think's going on here?
So yes, Your Honor. So for what I can make out, it looks like there was a FTA in July of 2018, and it looks like that was about 2 months after he was directly indicted. There was an FTA. The case was actually put on judicial hold by Judge Lagura on August of 2018 because of the FTA. And then nothing happened. I'm not sure if there was efforts to find him or whatever. However, I think what initiated this current case was he was picked up for the forgery and theft by deception. And then he actually did receive bond on those. So if you look in the system, you'll see he does have bond on those charges, but he was held on no bond with this case. I'm not sure why, because looking at his history, most of his history is drugs and driving. So I didn't find any violent history on his GCIC. So I'm not sure why they no bonded him.
Is there a CP case rattling around out there in connection with the forgery that you can see, Mr. Thomas?
Yes, Your Honor. So there is a CP case with forgery in the first degree and theft by deception, 20 CP 195070. And it looks like that case was initiated on October 28th, around about that time, 2020.
Okay, yeah, I'm looking it up. Okay, and that's what his bond is for. He got a bond just before Halloween of $12,500. It's a split bond where part of it is good and a little piece of it is a signature bond. Okay. All right. So you're suggesting, Mr. Lewis, that I set a bond on the burglary case, which is a second-degree burglary. You know, the allegation is that Mr. Brown was rattling around a business 3 years ago. That's what we're looking at. And he would be able to stay at that address on Beecher?
Yes, sir.
Okay. And what's your thought, Mr. Thomas, as to what we ought to do here?
So, Your Honor, as I look at it, it looks like the history is mostly, as I said earlier, drugs and driving. So I would not oppose a bond at this point, but I would like a ankle monitor, you know, to ensure we're able to keep track of them. I would oppose a bond in the amount of $10,000 for burglary in a second degree. And then I would also ask that he stays away from the location. The location was actually a house that was for sale, and he's alleged to have gone into that house and stole some appliances out of the house.
Okay, and it just was owned by some entity. It's not Fred Smith's house. It was Elephant Contracting or whatever the.
Let me just confirm with you, Your Honor, because I know there was a person who actually responded to it. But yeah, it was a residential managing property that owned the house.
Okay. Yeah, it says the victim was Elephant Properties. So you're right, vacant residential dwelling. So it was not a place of business, but it was vacant, which is why we've got second degree burglary. Okay. All right. Can we turn Mr. Brown on?
Yes, sir.
Thanks. Mr. Brown, where would you stay if you got out?
Well, that's my mom, my grandmother's, my family house. That's my mom and my uncle stay there.
Who else stays there besides your mom?
My mom's sister, my aunt.
Okay.
So you want to, may I add? I actually have my own construction business. I do construction. I was actually doing work inside their house, but I was working through a guy that I worked for, and he had the lockbox code and everything to get inside the house.
Okay, so I'm gonna stop you there because I don't want you to get into the merits of the case. It may well be that when you share that with Mr. Lewis, and he may be able to track someone down who can let the prosecutor know, hey, Brown was working at the house, and he just maybe wasn't able to convince someone that he was supposed to be there. That'll be a reason for the state to be flexible in working it out. Of course, you've got this newer case that needs to be accused or indicted. But mostly I want you to stay out of trouble because if you get arrested again while you're out on this bond will go away. And then you're a high risk individual to be sitting there in jail, given your condition. I am going to set a bond. I'll make it a $10,000 bond through the sheriff's 10% program. And I'm going to put you on initially pretrial supervision level 2. That means you have to report fairly regularly. They'll likely make it telephonic. But if everything is going well after a few months, if Mr. Lewis wants to reach out to have that level of supervision reduced, I'll do it. I'm not going to do an ankle monitor. I don't think you're a flight risk. I think whatever is behind you catching these other charges is what's going to be at risk, whether it's drugs or unstable housing or whatnot. But I hope you're doing well. You are an at-risk individual, so be smart with how you spend your time. And I will require you to reside at that Beecher Street address. And so Mr. Smith has it for the bond that he'll be filling out. It is 2062 Beecher, B-E-E-C-H-E-R Road, Southwest in Atlanta, 30311. Mr. Lewis, anything else for Mr. Brown?
No, Judge. Thank you, Judge.
Mr. Thomas?
Nothing else from the state, Your Honor. Thank you.
Okay. So I'll sign that the next day or so, Mr. Brown, and you and your family will see if that's a bond you can make, okay?
Okay, you just say how long, sir?
Say that one more time, slowly.
How long will it be before you post?
Before I sign the order?
Yes, sir.
Today or tomorrow.
Okay.
Okay?
Thank you.
All right.
All right.
You're free to go, Mr. Lewis. Thank you.
Thank you, Judge.
All right. Ms. Clark, do you need a minute to talk to Mr. Thomas? I can.
Mr. Thomas, do we need a moment to speak?
No, so you want to dismiss count 1 and reduce count 2?
Yes, that was the discussion with Mr. Whitenauer.
Okay, that's fine.
Well, look at that. I'm going to send you an email too, Mr. Thomas. I need new financing on my house.
He's getting it done, right?
Yeah. Okay, well, let's go back on the record. Give me 1 second. I'm juggling a few other things here. All right. We're going to get started with this at 4 o'clock. We need to take a break for about 5 minutes because I had committed to being on a conference call involving some legislation that's being proposed. It has to do with MARTA. It's not interesting. And it will not affect anyone here unless you also practice civil law. But I had to be on that call for about 5 minutes. Judge LaGrua didn't tell me this was going to take this long, but that's all right. We will get through. We've got 2 cases left, Ms. Perkins and Mr. Wallace. So we're going to start Ms. Perkins's plea. We'll take a time out, and then I'll get back on, and we'll finish Ms. Perkins's plea. Does that work?
Yes, sir.
Good, because you don't have a choice. All right, Ms. Perkins, in an ideal world, you would be here in court to take your plea, but you are down at the South Annex. Do you waive your right to be in person?
Yes, sir.
Okay. And you also have a right to have Ms. Clark by your side during this plea, but she is in her remote office and you are there. Do you waive your right to have Ms. Clark by your side?
Yes, sir.
Okay. If you all need to speak in private, let me see if I can actually offer that. Yes. So South Annex, I can move into a breakout room. So if you do need to be speaking in private, let me know and I'll get you guys into a private space. Okay.
Okay.
All right. And you'll need to make sure you speak up so that Ms. Rivers can take this down. Mr. Thomas, when you're ready.
Yes, Your Honor. Thank you. Ms. Perkins, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your true, correct, and legal name.
Daniela Nicole Perkins.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone to school?
I'm 26 and I received my GED.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you're being charged with the following offenses? Robbery, aggravated assault with a deadly weapon, and possession of a firearm during commission of a felony?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you received a waiver of rights form from your attorney?
Yes, sir.
Have you had the opportunity to sign that waiver of rights form from your attorney?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Clark, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Has your attorney advised you of the minimum and maximum sentences for each charge you are pleading to?
Yes, sir.
For robbery, the minimum is 1 year, maximum is 10 years. Aggravated assault with a deadly weapon, minimum is 1 year, maximum is 20 years. And possession of a firearm is 5 years consecutive.
Yes, sir.
Ms. Clark, do you waive formal reading of this indictment?
I've reviewed the indictment with my client and we do so waive.
Okay, and do you waive any and all defects in this indictment?
So waive, but I would like to correct the record with regard to robbery. The sentence range discussed with my client is 1 to 20 as opposed to 1 to 10.
That's correct. Okay. Ms. Perkins, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, sir.
Do you understand that pleading guilty to aggravated assault with a deadly weapon, you are pleading guilty to a serious violent felony?
Yes, sir.
Do you understand that you will be that, hold on 1 second. Okay. Do you understand that you will serve the entire prison portion of your sentence imposed for a serious violent felony without possibility of parole?
Yes, sir.
Do you understand that while you would be eligible to be considered for participation in Department of Corrections administered transition center or work release program during your final year for your incarceration, you will not be eligible for any other sentence reducing program of the Department of Corrections or Board of Pardons or Paroles?
Yes, sir.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or Board of Paroles or Board of Pardon Paroles, and no one can guarantee parole?
Yes, sir.
Do you understand that if you are sentenced as a recidivist under Section Code 17-10-7 B or C, or under Section 16-8-83, you will serve the entire prison portion of your sentence imposed without a possibility of parole, and that this is true regardless of any advice from your attorney or anyone else?
Yes, sir.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court the sentence of 10 years served to committed to time served, 100 hours of community service, proof of employment, and a probation fee waived, and these are just conditions. Probation fee waived upon proof of college courses.
Yes, sir.
Can you repeat? Sorry, can you repeat that, please?
Yes, Your Honor. And Ms. Clark, you can correct me if you're going to say something different. So 10 years served to committed time served. It was balanced probated, correct? Okay. 100 hours of community service, proof of employment, and the probation supervision fee waived upon proof of college courses.
That is my understanding, Your Honor. And that is what was relayed to Ms. Perkins and what she signed.
Okay, explain to me that last piece, meaning if Ms. Perkins is enrolled in college as opposed to working, then she doesn't need to pay a probation supervision fee.
That's correct, Your Honor.
Okay, but if she's working, if she's running a business, she's going to pay the probation supervision fee because, of course, she'll be earning income.
Yes, Your Honor.
Okay.
And Your Honor, well, never mind. I'll hold mine. I apologize.
We'll get there.
Okay. But the court does not have to accept the recommendation. The court can sentence you to a maximum of each charge and can run these sentences consecutively or one after another.
Yes, sir.
Do you understand that if your guilty plea is a blind, I'll skip that part. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including in federal courts?
Yes, sir.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice from your attorney or anyone else?
Yes, sir.
Do you understand that neither the court, your attorney, nor district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you?
Yes, sir.
Do you understand that there may be other adverse and unfavorable consequences as a result of this guilty plea conviction, just as there would be for a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, and transfer a firearm, and the ability to obtain employment.
Yes, sir.
Do you understand that you are pleading guilty to a felony if you use, possess, receive, or transfer a firearm, or use a firearm in a crime? You will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes, sir.
Do you understand that you waive any of all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
You understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes, sir.
You understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent, the right to incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or the court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf or present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if conviction of these charges at trial.
Yes, sir.
Has anybody forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony in indictment number 19 SC 166817?
Guilty.
Is this guilty plea freely and voluntarily given with the knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, sir.
So Your Honor, this will move into trial. The state would have proven beyond reasonable doubt that on the date of October 4, 2018, officers were dispatched to the location of 2625 Bluestone Drive, which is in Fulton County.
Can you say the street name again?
Bluestone Drive, Southwest.
Bluestone, okay.
Yeah, one word. The officers met with the victim who was on the floor bleeding from a gunshot wound and advised that they met with a girl named Nikki, which was later identified as Miss Perkins, who was in the home. As she was leaving the home, two men came in, and one of the men did shoot the victim. And a wallet was taken along with some other items. Fingerprints, latent fingerprints returned for GPI did match Miss Danielle Nicole Perkins.
So that was a little murky. Let's try that again.
Okay.
So there's a guy who occupies Bluestone.
Yes.
And Ms. Perkins is in the house with him.
Yes. So Ms. Perkins was invited over to the house by the guy.
Okay. And then she says, I gotta go. And as she's leaving, these two guys come in and shoot the victim and take his stuff.
Yeah, so from the way the police report reads, the victim asked Ms. Perkins to leave the house eventually. As she was leaving, these two guys came in, eventually shot the victim, took possession of the victim, and Ms. Perkins and both of the other co-defendants left in the same car.
Okay, that little piece I didn't get because the indictment is an interesting read. It sounds, it alleges all these offenses, but for each of them with Ms. Perkins, it's party to a crime. So yes. The state is not suggesting that Ms. Perkins shot the victim. The state is not, and we should be clear who that is. The victim's.
Yes, Matar Kente, and that's my best.
Yeah, so first name Matarr, last name Kanteh. So Mr. K is the victim. He gets shot, but not by Ms. Perkins, by these two guys with whom she leaves.
Yes.
Okay, so that gets to the heart of my question, which is, what's your evidence she had anything to do with it? And it's whatever she's doing in the house, this guy wants it to stop. She says, leave. He says to her, leave. Coincidentally, as she's leaving, these two guys bust in, even more coincidentally, to the point of criminal liability. She leaves with those two guys.
Yes, Your Honor.
Okay, got it. I also understand the recommendation in light of all that.
Thank you, Your Honor. That's all from the state.
Okay, Ms. Clark, our probation contact had to step off to deal with some things because this went later than she had forecast as well. Oh, she's back.
No, Judge,
hello,
I was able to make that.
She's back.
Hey, Judge.
Excellent. What I was going to say is that Ms. Crawford had told me that Ms. Perkins does not have a felony criminal history. Is that your understanding, or you have a different understanding, Ms. Clark?
She doesn't have anything active. She does have a case out of Richmond County where she used first offender in 2018.
For what?
It was a credit card theft felony.
Okay. Got it. Okay. So she has a prior and query whether it was before or after, but either way, she used up her first offender on that.
Correct, Your Honor.
Okay. Got it. So Ms. Clark, tell me what you want to about Ms. Perkins and her case.
Okay, as much as I'd love to go, I would like to remind the court it's 4:01 if you need to.
Oh, thank you. Right. Wow, you're better than an alarm system. This is a perfect time to break. You can't see me, but you can hear me. I'll be back, and it will be the defense's turn to talk. Sit tight.
Did you go to his meeting? Did you go to his meeting in the back? Yes. 5 minutes, right? Roughly. I hope. It's a conference call, so I don't know how long it'll take. He said about 5 minutes, though. It's all good. It's all good.
So Carl, when was your birthday, man?
August. Yours in August. You're Leo?
Yes.
Oh, okay.
Yeah, Leo.
I'm a Cancer. I'm in July.
Better to be one than have it. Promise you.
I
Been
heard
through it. Been through it.
Yeah, I
twice
know. I
already.
remember you told me all about it, man. I said, yeah.
But,
You broke it down to me.
I'll turn this. 63 this year.
That's what's up, Carl. My mom is 61. I think 4 or 5, one of them. So yeah. I respect that.
Yeah.
I remember the whole thing, you know, your process and all that. I do. Like, I remember, man, like from day one, I remember that.
It's been a heck of a ride, I'll tell you.
That's what's up, Carl. So is Judge done missing you? I know the judge is probably missing you.
Judge Brasher?
Yeah.
Well, he's been very busy as chief judge.
He's been busy.
But yeah, he's going to get back into swing things. He's going to be doing some criminal stuff and doing a fair amount of civil stuff right now. So I'll be able to go back in. And what I do on civil cases is I always notify counsel a week or so ahead of time, have them send out a form. I'll send the form, let them send it back to me, let me know they want me to take it under proceedings. That way I can count that schedule.
Here's what you got going. I got you.
Because I'll be not only covering him, but from time to time I'll be helping Karen out since we're going to be right next door to each other.
That's what's up. Carl is the man. Come on, man.
Caught me off guard with this stuff this afternoon.
But you know what, Carl? Did you used to be before Judge Bratcher? Was you in Adams courtroom? You was. I remember that.
But yeah.
Oh, is it?
Yeah.
Okay.
I was with her from June 13th to December 15th. Judge Bratcher.
I remember that. Every time I used to work they just put me in a lot in there when I was, I remember that, man. Pretty good, pretty good.
I was, when I was diagnosed with cancer for the second time, I had resigned my position at Judge Adams and just taken a federal job that day. And then I got that, I took a federal job that morning, and I got told to go back and start doing it. I've had a couple more opportunities to go through. It's enjoyed working with Jeff Bratcher, enjoyed working with Jeff. So, you know, this, when I retire, I might look at any job here in IT person. This is much better as I'm doing.
Exactly. I say that, Carl. If you wanted to be.
Okay, and then I'm taking records at the same time. I just have to notice Karen was on here. And the judge did too, and he's going, what's she taking now? So he asked me, and she said she was, so it's like, okay, well, you have that and Carl can my.
No, it's like.
I know a guy that's been a floater for 20 years.
So you say, hey, it's more than like.
Almost. He's only been in court. He said he had a dispute in court. Maybe 8 days. Is lighter. It's a little more complicated in that they have much shorter time frames to get stuff done. I mean, everything they do has to be turned into. But they also have volume, we have stuff to do, and they also have service reports.
Every department.
Mm-hmm.
Trust me. It ain't just.
I've been trying to get my son, he was disaster recovery specialist for Norfolk Southern Railroad for several years. And then left there, he's working with Intercom radios station of the company, which is B103 and several other radio stations.
Yeah, I think that is.
He's an IT person there. I've been trying to.
You said, you don't know, right? I just see them building, so.
Oh, yeah.
There's a headquarters somewhere, I seen it, yeah.
I keep sending him any kind of job position for IT. He comes through here, so he would be. No, I definitely understand that. I'm sorry.
That's what they got saved.
And I said, you're already used to being a call 24/7, so it's not like a really big change for you. Right. And, but right now, his partner or roommate that he's living with, they both work at the radio station now. His partner's about to go work somewhere else. And my son's going to be there at the radio station. And it's, he's basically the only one at the radio station now. Because he has it set up so all of the sportscasters and all of the DJs can do. He's the one that sits at the radio station to make sure.
Your thing is
It's basically what I'm doing today. Okay. I checked out went in and checked out the sound system and or maybe yesterday. Make sure that it's up and working like this. I'm going to be out next week, and that's going to be Kieran's first week full time. So I want to make sure everything is working before she comes in, so she just has to go and sit down and just start working. She don't need work.
Yeah, my brother is a good, he's a cool judge too. I always had good judges too. I mean, I never had like, it's been life.
My very first day I was supposed to be in here, we had a bit of confusion because Mr. Rusher, we'd gone to lunch one day, and he told me, he goes, by the way, I'm going to be sharing the judgment
Wow, we're down to so few screens.
Yes, I blocked out some of the ones that we haven't.
Great.
We're not really using.
I was doing the same. I was closing down a bunch of the booths. I noticed you at first, like, uh-oh, something bad is happening.
I was watching.
Good. There is Miss Perkins. Great. There's Miss Clark. Better not have lost Mr. Thomas. He's earning good time here. There he is. All right. I am back. And of course, the award for patience goes to Mr. Wallace. We will get to you, Mr. Wallace. You are up next. Ms. Rivers, are you still good?
Yes, I'm back too, Judge.
Great. So Ms. Clark, can you hear us?
Yes, Your Honor.
Great. And Mr. Thomas, you're still good?
Yes, sir, but we do not see you.
Oh, that's because I haven't turned myself on yet. There I am. And thank you, Ms. Clark, bonus gold star. I made it to this conference call about MARTA legislation. So it's moving along. Where we left off on the record was Ms. Clark was going to start talking about Ms. Perkins's situation. Ms. Crawford had shared that Ms. Perkins does have we'll call it a prior, a first offender conviction or first offender adjudication for financial transaction card theft out of Richmond County. And then Ms. Clark was going to start talking a little bit about this case, which is, given the charges, not your typical case.
Yes, Your Honor. Can you all hear me?
Yes.
Okay, perfect. So, Your Honor, before you today is Ms. Daniela Perkins. She is 26 years old and has been in Fulton County's custody since about March of 2019. I actually have the date. March. All the movies back and forth. March. March 13th of 2019 is when she was taken into Fulton County custody. This case actually happened back in October of 2018. And so our facts are just a bit different than the state's in that my client was actually in the room. What she indicates to me is that she was in the room with the victim at the time that the shooting began. However, she does admit and did admit that she unlocked the door for the people who came in, and she actually had to take cover herself when the shooting began. Since the various conversations, we actually did a site visit with Mr. Whitenauer and 2 Fulton County law enforcement officials back in January. And at that time, Ms. Perkins shared information, and it's based upon that information that we were able to come to this agreement. We've had several bond hearings and been to court quite a few times in this matter, as you can imagine, in the last 2 years almost. And so that is where the facts differ slightly for us, that they didn't come in as she was going out, but nevertheless, we are here. Your Honor, we are asking that the court accept the recommendation of 10 years to serve 2, balance probated, and I do understand, so actually we're gonna ask for a slight modification in that with the possession of a firearm during the commission of a felony, I do understand that that requires a 5-year consecutive sentence. So we would ask the court to sentence Ms. Perkins to 5 years to serve 2, commuted to time served, balance probated on counts 2, armed robbery reduced to robbery, and count 3, aggravated assault with a deadly weapon, followed by a 5-year probated sentence on the possession of a firearm during the commission of a felony. As I said, she has provided information, has agreed to offer truthful testimony when and if that is needed at the time of the prosecution of the other now known assailants in this matter. Your Honor, Ms. Perkins does have 2 sons, and her mother actually coming into Atlanta this evening to stay at a hotel until she's released and they can drive her back home to Augusta. So at some point she will be petitioning or requesting from probation to be allowed to report in Richmond County. Her mother is very involved in her life and has been in court when she could be in court, and once COVID hit, she was not permitted to participate in the Zoom court, but she has been actively, communicating with me, updating me on what she's doing and getting in place for Ms. Perkins upon her release. So Ms. Perkins does have a nice, comfortable home to return to upon her release. She will not be in the Metro Atlanta area and has no reason to be around her would-be co-defendants and the actual assailants in this matter. And as you see, she is charged as party to a crime in this particular case. As she indicated, and we of course met many, many times, I have many yellow jail visitation slips here from the course of our representation. We've talked a great deal about this case. Ms. Perkins has expressed her remorse for her actions in this particular incident. And we're throwing ourselves at the mercy of the court and the DA's office, but particularly the court, because we know you do not have to accept this joint recommendation. So I can answer any questions that the court may have at this time, if there are any.
Okay, I may have a couple for you. I'm going to start with actually Mr. Thomas. First question, I forgot to ask if you had any victim impact information you wanted to share.
I do not, Your Honor.
And any restitution that you think Ms. Perkins should participate in?
No, as far as I know at this time, there's no restitution owed.
Are you aware, Mr. Thomas, of whether there has been any success in identifying who the more actively involved perpetrators are in this case?
So, Your Honor, Ms. Clark did say that they have been identified. As I said earlier, I'm fairly new to this case, so I haven't dug all the way into the case yet. So I am not sure if they have been identified, arrested, or if we're even looking for them yet.
Okay. Ms. Clark, then your turn on that one. And I gathered what you said, and we don't need specifics right now, but it's one thing for law enforcement to be told, yeah, it was Black and Two Fingers. Well, I don't know how we go find those guys, as opposed to it's this guy, that's his picture, and then the police know who to go get because they've got a driver's license photo or a booking photo.
Yes, sir. Thank you for allowing me to clarify. And so that is where we were early on. We had their nicknames, we had descriptions, and even in our own independent research with Ms. Perkins' help, we were able to go to their Instagram pages and subpoena information, but we're not able to get IP addresses. So fast forward, 15 months, we actually did a site visit with Ms. Perkins. She knew where they lived, and they lived fortunately in homes and not in an apartment complex somewhere. So we went to their homes, two of their homes, and one of them was a set of cousins and another was a neighborhood friend, and that's how they became close. But went to their homes and got license plate numbers as well as the addresses. And we did reverse, both Mr. Whitenauer and I did reverse lookups on those addresses. Now, what I will say is we do not know full last names. We have first names and nicknames, but we do have those addresses. And I have not, due to the transition and all the things that were going on at the DA's office, I have not spoken with Mr. Whitenauer since a day after we did that visit. So I don't know what information he was able to further get, but based upon his communication, because he couldn't relay this offer until speaking with the supervisor. And so based upon the fact that he was able to make this offer, it's my understanding that it was fruitful, but he did not say that explicitly. So I want to clarify that.
Okay, but the efforts you describe are significant, meaningful efforts, and that's what I wanted to understand. If it was tossing out a effectively meaningless nickname or something far beyond that, and it was something far beyond that. And you're saying, Ms. Clark, that Ms. Perkins has been in custody since March of 2019.
Yes, Your Honor. And she was actually in custody in DeKalb since before then, but she was in Fulton County custody as of March 13th, 2019, per the booking sheet.
Okay, how old are your sons, Ms. Perkins?
They're 5 and 7. My youngest son will be 6 in June.
So they've missed you for a couple years. They're growing up without you.
Yes, sir. And they're without their father passed away in 2017, so I'm the only parent they have left.
Okay. Have they been doing okay in these 2 years? Are you able to stay in touch with them?
Yes, my youngest son was actually accepted into the gifted program, and he's only in kindergarten.
Well, that's an early start for being gifted. Good for him. All right. Anything you want to add, Ms. Perkins?
Yes. When this long ride began, I can honestly say, I was very immature prior to getting arrested. I had issues, but since being incarcerated, I've learned a lot of things and I've grown a lot, because doing time will do that. And in this time, I've missed so much of my children's life. I missed so much of my own life, my mother, I've lost family members. And I realized that time is a gift, and how you spend it depends on you and your mindset. And I've learned that very much being in here, meeting different people, reading different books, being in different programs in the jail. I've learned that, this is my second chance.
Okay, that's an important lesson. The key will be to apply that lesson when you get out, and figure out, it's people, places, and things. So you're going to need to be thoughtful about who you spend your time with and where you spend your time. And I think that will help you chart a different course. Certainly your 2 boys need you to be much more present in their lives than you have been the last few years.
Okay.
All right. Well, I find there's a factual basis for your plea. No one is saying you had the gun or pulled the trigger, but you were mixed up in something that could have ended even worse. I mean, it sounds like it would have been terrifying for the victim. But we are all blessed that the victim survived what happened. We probably wouldn't be talking about 2 years to serve if he had not survived. I also find that your plea is knowing and voluntary, which means you've understood everything we talked about and you don't have any questions and no one has forced you to enter this plea. Is all that true?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that when you are on probation, which you will be shortly, if you have a technical violation, like you miss a meeting or something, you and probation will work that out. But if it's something more serious, new charges, or you just disappear, then that'll come back to a judge to work through. You may have asked this, Mr. Thomas, but Ms. Clark, do you have any objection to proceeding on a copy of the indictment? That's what we've got here.
No objection, Your Honor.
Okay. Ms. Perkins, if you were here in court, you'd actually sign the indictment today saying, I'm guilty. but you are down in Union City. Do you authorize me to sign the indictment for you?
Yes, sir.
Ms. Clark, may I sign for you?
Yes, Your Honor.
And Mr. Thomas?
Yes, Your Honor.
Great, I'll take care of that. And finally, Ms. Perkins, I'm going to sentence you on count 2, which has been reduced to robbery, and count 3, aggravated assault, to 2 years to serve. I will reduce that to time served, which isn't real magnanimous of me because it only knocks off about a week or so, but I'll reduce it to time served. Count 4 has to run consecutive to those counts. I'm going to probate it. It has to be 5 years. So overall, it's a sentence of 7 years to serve 2 years. Those 2 years are reduced to time served, and then you'll be on probation for 5 years. That's a few years less than what Mr. Thomas asked for, not because his recommendation is unreasonable. Am I changing it? I just find that real long periods of probation don't make a lot of sense unless someone owes $50,000 in restitution and it's going to take a long time to pay. We're going to know in the next 18 months whether you're living up to what you want to be for your kids. And
Is that me or is he still here?
Yeah, you're muted, Judge. So, Your Honor, you're muted. Yeah.
Mm-hmm.
Judge, we're not hearing you.
Can't hear you, no, sir.
Judge, if you can hear us, you're muted.
Judge McBurney said that they're having technical issues in court, so we can just stand by for a moment.
Okay.
oh, you just something popped back up.
Hear you.
And we
Can
can
you hear
hear
me
you
now?
now. Yes.
Great. Hold on one sec. Did you remember what booth Mr. Wallace was in? We never got that one.
Let me see. I'm disconnected. He was in, I want to say 4 South Booth 1, I believe.
I'm sending stuff to Shay. So Ms. Rivers, you can hear me now?
Yes, I can, Judge.
Okay, not that you guys are interested, but what happened was the time expired for the Zoom call, which doesn't disconnect us, but it kicked out all of the jail booths, not South Annex, because they're not connected through Zoom rooms. And when that happened, it shut down the audio in here because that's all connected through Zoom rooms. We'll see if we can get poor Mr. Wallace back on. But what I was in the midst of saying to Ms. Perkins was, and I was repeating myself, but you don't need 1,000 years of probation for us to figure out if you're heading in the right direction. And so that's why it's 7 to serve 2. I'm gonna have several special conditions of probation. 1 is that you complete 100 hours of community service. 2 is that you either maintain employment or you are enrolled as a full-time student. If you are enrolled as a full-time student, you do not need to pay probation supervision fees. You're going to need to stay outside Fulton County. It doesn't sound like you have any good connections to Fulton County. This case is your connection to Fulton County, and I don't know that you're going to have a lot of warm recollections about that. So while you're on probation, you need to not be in Fulton County. There's not a problem having you supervised out of Richmond County. You may initially report to probation here in Atlanta. That won't be a violation of your probation, but it may be that you can report directly to Richmond County. I'm going to let Ms. Crawford, our probation consultant, let you know how that's going to work. I'm going to put you and Ms. Clark, so you, Ms. Perkins, and you, Ms. Clark, into a breakout room with Ms. Crawford to work through that. Mr. Thomas, anything else in Ms. Perkins's case?
No, Your Honor, I think that'll be sufficient.
Okay. Ms. Clark, anything else?
Nothing further, Your Honor. I would just like the record to reflect that I did explain what special conditions mean as relates to revocation, if there were to be one, to Ms. Perkins.
Okay, so Ms. Perkins, a normal condition of probation is something like you got to show up at your meetings when you have them. And if you violate a standard condition of probation, there's a ceiling on how much you can be revoked for. I don't remember if it's 6 months or a year, and that may seem like a lot, but at least there's a ceiling. If you are shown to have violated a special condition of probation, then the judge can revoke all your remaining probation. And that's the reason why judges say this one's special, meaning it's important. Don't violate that one. So you coming to Fulton County would be a violation of a special condition. Bad choice. Things like that. Oh, I know. One other special condition I meant for you to have would be no contact with the victim and no contact with any co-conspirators. I can't call them co-defendants because they haven't been indicted, but co-conspirators. And you know more about who they are than I do, and it doesn't sound like we've got full names, but just you need to stay away from and not have communications with any of your co-conspirators from this case. Okay?
Yes, sir.
All right.
Your Honor, if I may.
Mr. Thomas?
Is there any way we can add a condition? I know we already talked about it, but just make it a special condition. Continue to cooperate in the with the DA's office.
So that's an interesting one. It's a fair request, but I don't know that courts are appropriately used to compel testimony unless you're offering immunity or something like that. So there are often defense attorneys who wisely say, could you please not have that in a publicly available document? So I'm not going to do that. I understand the request. But if Ms. Clark agrees with it, because that's something she's talked to her client about, then I'm happy to have some generic language to continue to assist the authorities in further prosecution, something like that. But it creates problems for the prosecution as well as for this defendant if there's some judicial leverage being applied to get someone to cooperate if they don't otherwise want to. Again, short of offering someone immunity and then they refuse to testify, then they're in contempt, but that's a different proceeding. Ms. Clark, how do you want to handle that one?
Your Honor, I will defer to the court.
Okay, well, if you don't object, then I'll add as a condition that Ms. Perkins is to continue to cooperate with the authorities in connection with her case.
Understood.
Okay, thank you for catching that, Mr. Thomas. That may prove useful to you if you inherit the rest of this. Okay, I'm going to move Ms. Clark and the South Annex into a breakout room with Ms. Crawford. Okay?
Thank you, Judge.
Okay, good luck.
Thank you.
All right, Mr. Miller, we are doing our best to get your client back on the screen. We lost our connection with the jail because time expired on our Zoom date. And I noticed while I was wrapping up with Ms. Perkins, someone was pulling up different booths where we thought your client had been. But they were empty, and it may be that the jail said, oh, they hung up on us, they must be done, which is unfortunate because we weren't done, and your client and you, because I've seen your name on the Zoom call, you all have been waiting patiently. Hopefully you've been multitasking and doing other things, but poor Mr. Wallace was just sitting there, probably on a chair with no cushion. So I don't know if Ms. Alexander has a connection out at the jail that would let us know if we need to call it quits, and we will reschedule Mr. Wallace for a plea in the near future, or if they are endeavoring to get Mr. Wallace back.
So Judge, your call. If you need for me to get the defendant back, I'll make it happen. Is it just one more?
It's just Mr. Wallace, that's it. But let me ask this before you do that. Is this a complicated plea or is it pretty straightforward, Mr. Miller?
It is a negotiated plea, Your Honor.
Does it get your client out, or is he going to be serving more time?
He's going to be, it appears that he's going to be transferred to Carroll County.
Okay, then I don't think this is a rush. Doesn't mean we need to wait 6 months, but the jail went sort of above and beyond today to make all this work. And if they've already put Mr. Wallace back in general, then my thought is we just get Mr. Wallace onto one of my calendars or something soon to take this plea. But if the plea was not going to get him out into the open, fresh air, then I think we ought to, at 4:40, say we're done. But Mr. Miller, you've been patient. If you want to call in a chip, you can do that today.
I mean, I would like to move forward, but I do understand. We've all been at it all day. Mr. Wallace just called me and said that he was waiting his turn and that he was informed that the court had ended the Zoom session. And I told him that it was probably some type of technical difficulty that would be addressed. And then I rushed off the phone in order to address the court.
Okay. Well, Ms. Alexander, I'll defer to you. If it's not a big production, let's just finish. If it is a big production, Mr. Wallace is not getting released. And so we just need to live up to our word of getting him on a calendar soon.
Right. So Judge, if he's not, if there's no reason and he's not going to be released today, we need to schedule it for the next calendar because it would be.
Okay, we'll do that. It sounds like we have perhaps overstayed our welcome in all those booths today as we tested this process out. It was an important experiment and we're going to learn a lot from it. So Mr. Miller, I'm going to ask you to work with Mr. Smith, the litigation manager who is sort of shepherding Judge LaGrua's formerly Judge LaGrua's cases, but Mr. Smith can let me know what you guys line up and we can see if we can add it to one of my calendars. And then we'll just figure out with Mr. Thomas, you know, if it's Zoom, people can dial in. If it's going to be, we bring Mr. Wallace over here because it's one of my inmates I brought over days. You guys can still Zoom in, but we'll just get him that way. If we've got the capacity there, we'll just make sure that it happens in the very, very near term. And hopefully, Mr. Miller, you'll explain to Mr. Wallace, you didn't do anything wrong, he didn't do anything wrong, and we didn't hang up on him. It just was a technical issue.
Absolutely, and that's perfectly fine, Your Honor. The only issue that I had anticipated was part of the sentence, we were going to ask that a special condition be added, and that was that he report to the Georgia Works Program. I did speak with the records office at the jail, and they indicated that because of the hold, that would conflict with their normal procedure.
Right.
And so they did say that maybe if I created an order that will allow him to report to the program from the street, the order signed by the court, then they would transfer him to Carroll County. And then at the conclusion of his business in Carroll County, he then would be required to report to the Georgia Works program.
What, do you have any idea what awaits him in Carroll County?
I do not, Your Honor. I was on the phone with Carroll and Mr. Wallace and the records office at the Fulton County Sheriff's Department. So I was switching back and forth. But with the delay, I should be able to get that information between now and next time he's on the calendar.
Yeah, why don't you do that and then work with Mr. Thomas on that? I think that that's a fair request, but if Carroll County is going to be a 6-month visit for him, we don't want to do that because who knows what Georgia Works will be doing at that point. And so I think we can get a tighter resolution to the case. And I'm assuming it's a negotiated plea.
It is, Your Honor.
So that'll give you a minute, Mr. Miller, to sort things out with Carroll County, and then we can see how best to structure that. Okay. So, Mr. Miller, you work with Mr. Smith. He'll let me know when we're going to try to get Mr. Wallace on one of my calendars. Okay.
Okay. Thank you, Your Honor.
Thank you. South Annex, thank you so much for your patience today.
You're welcome, sir. It's always good to see you.
Same.
Enjoy the jokes.
You too. Be safe.
Okay.
Ms. Crawford, thank you. I'm sorry that we went beyond your normal span, and I hope you were able to address what you needed to address.
Yes, Judge, but I still have that situation that I wanted to talk to you about earlier. I don't know if you want me to call the chambers or we can stay on after everybody else. Whichever you want to do is fine.
We're both right here, so we'll shoo everyone else in a minute.